I appear for impeding applicant in this case. Impeding applicant in this case, Your Lordship. The petitioner on the guise of pendency of writ petition is trying to grab my property. Hence, the hearing of this petition may be posted to save the rights of my property, Your Lordship. Kindly have it on tomorrow.
Petition will be for learn a single judge. It is to be listed before this court.
No.
It is appeal petition. What is it?
No, writ petition, Your Lordship. I am for impleading applicant. I am impleading applicant, Your Lordship, in this case. PIL.
PIL will come when it is coming. When it is coming, the PIL will be posted, your application will be considered. Yes.
Make one submission. Serial number 17 will not come inconvenience today.
17.
Yes.
My lord, let Mr. Mahesh Chaudhary be present, my lord.
I see.
Last date of hearing and adjournment had been taken.
Yes, Lord, I smite.
Fish processing unit.
Some inconvenience today. I will inform the Mahesh Chaudhary is not opposing.
That is
Why he is not? Mahesh Chaudhary's client's order has been in 2 weeks, 4 weeks.
Lordship. You are running your tech or your unit, you are running your unit.
It's closed, it's closed.
Sure. Surely closed. We'll come to see that.
Please, my lord, we welcome.
4th of March.
Please.
Lord, item 51, my lords. Lord, item
Yes.
My Lord, MRPL, which is a central public sector enterprise under the Ministry of Petroleum, had called for a tender for upgradation of its electrical system, setting up of a new substation. The writ petitioner was successful in getting the tender. He should have completed within 9 months. He did not complete. Despite 3 extensions, he was unable to complete. So therefore, we communicated that the contract stands terminated. He challenges in a writ petition, and the learned single judge comes to a conclusion that there are disputed questions of fact. He has to go before the arbitrator. Not against that, a writ appeal was filed. During vacation, the vacation bench has granted stay against calling for new tender. Lord, our operations are suffering. We are unable to call. And my Lord, the writ appeal was listed once again on 8th of January. It did not reach, so it was adjourned to 18th. I have filed an application for advancement. Would your Lordship take up that application for advancement?
On 8th.
It was listed on 8th of January, got adjourned to 18th of February. We have now filed an application for advancement. If your Lordship could take up that application, my Lord, during this week, a date may be fixed then.
Application can be taken up tomorrow.
Yes, please. Very well. I'm grateful.
See the.
Yes, my Lord. I'm grateful. I'm grateful.
53 minutes. Praise for a short
I'm moving a memo for a writ appeal. The appellant is a nationalized bank, my lords. The learned single judge has allowed the writ petition filed by the borrower. Now the borrower has filed a contempt petition which is coming in the first week of February, my lord. This could be taken up before that.
Appeal.
Please, my lord. My recovery proceedings have been set aside.
29th of January.
One more writ appeal. One of the single judge, my lord, the revenue entry which stood in my name, my lord, has been restored in the previous person, my lord.
Order.
The revenue entry which stood in my name, my lord, has been directly restored in the previous person, and the previous person is not is deceased, my lord, already. In the difficulty, my lord, and the direction has been issued to the revenue authority to change the revenue entry.
So, your appeal.
Please, my lord.
What is that? Petition, appeal, PIL? No urgency. 5th of March.
The revenue authorities are making active efforts to change the revenue entries which stood in my name.
We'll change, we'll set aside if you are right. No urgency. 27th February.
Lordship, writ appeal, your fresh matter. Appellant has invested 8 crore to the beach development where now tourism and its chief minister recommended to continue the same.
No urgency. Your recommendation of chief minister doesn't make any urgency.
PIL.
It will go to 12th March, yes. Yes,
PIL is
not in the middle, yes.
Lordship, this is the tree cutting PIL matter, your lordship.
Pardon?
This is a tree cutting PIL, your lordship. The PIL filed against cutting of trees in Bangalore. The BBMP has now passed an official memorandum, your lordship, for cutting of over 500 trees in the center of Bangalore. We have filed an application challenging this since several orders of this honorable court have not been met in this regard. There is urgency, your lordship, since the tree cutting process is beginning now.
So it is an IA in PIL.
It is an IA in PIL. It may be taken up, your lordship, since.
So whenever PIL comes, it will be taken.
The urgency, your lordship, is that the PIL is listed next month. However, the official memorandum says that the tree cutting process can begin even as on today, your lordship, hence, by the time the PIL, the trees will be already cut by the time the PIL is taken up, your lordship, which is the only urgency here. Maybe taken up tomorrow or day after, we'll address our submissions on this application alone, your lordship.
Day after.
Lord, field number 56, my lord.
50?
56, my lord. We've already taken steps, paid the process.
Pardon?
Murder. In respect of murder, steps in respect of 1 to 3, or it needful is done, and it may be posted after service of notice. And respondent, contesting respondents are here. And in respect of murder, the government authorities, we have taken steps today.
You want time?
Yes.
All right. 13th
May I,
March.
Lordship?
May I please, my lords? Lord, item 51, my lord.
My lord, serial number 23, my lord. Senior
20
is out of station.
23.
23. It may be have it on after 2 days, my lords.
After?
2 days,
After 2 days.
2 days.
6th February.
Much obliged.
Serial number 28.
My lords, item number 71, my lords. I seek for a short accommodation, my lords.
6th February.
Serial number 28, my lords.
6th February.
28, my lords. 28, my lords. Serial number 28.
Yeah, 9. Senior is not well. So
There is a delay of 69 days. We'll issue notice. Notice to the respondents returnable on 11th March. In delay application. Yes.
Serial number 28, my lords. They appear
28.
for the complainant, my lords.
Pardon.
Seeking for an adjournment in this matter, my lords. So, council on record has some inconvenience today.
Which date then? We go to
Any date convenient to.
20th February.
Please, my lords.
Lord, item 51, my lords.
Serial number 59.
Still number?
It's 59, 59.
59.
59, yes, my lords. Kindly adjourn it for a week, my lords. It's there for compliance. I'll comply it in a week, my lords.
No, office of this. So we'll say 59. In 59, 3 weeks the time is granted to comply with the office of this. Dealing with
May I, Lordship?
petition shall stand automatically dismissed without order of or reference to the court. Then 60 may same order. Then 59 may 2 weeks. 58 may 4 weeks in same order.
Your Lordship, may I make a mention?
That's all.
Your Lordship, I appear in 60.1, Your Lordship. A date may be fixed, Your Lordship. It's coming for non-compliance for the 4th time, Your Lordship.
So we are granting time you comply with.
I'm for the, the connected matter, I'm for the respondent, Your Lordship. They've not been complying it for,
So you said that unless within 3 weeks it will automatically happen.
please, Your Lordship.
Lord, item
May I, Lordship?
51, my lords.
Yes.
My lord, with respect to item 51, my lord, the engaging counsel is on some inconvenience, my lord. Lordship may have it of the next week, my lords. 51. WP 102601 of 2023. Green bench matter, my lords.
21st January, 21st February.
May I, Lordship?
Grateful, my lords.
May I, Lordship?
Yes.
Lordship, serial number 57. All the office objections were complied, Lordship. And the matter was last heard was before the previous vacation in 24. If a short date can be given for a detailed hearing, my lords. There is
Which
also an
one?
interim prayer pending.
It is listed today.
It is listed 57, my lord.
Listed with which number?
57, serial number 57.
57.
Yes, my lords.
So it is there. It will reach one time.
If it doesn't, I thought it's a second half, there are other matters, so I thought I'll request for a
We
short
do
date.
not know. How do you know that second half is other matter? We also do not know which matters are.
At 2:30 PM, there are some matters, my lord.
No,
Hence,
it will reach and will taken up. If you want time, it can be given. If you want
obliged.
time- If you want time, it can be given. Otherwise, no miscellaneous mentioning.
No, my lord, I'll wait for it, my lord.
Yes.
Thank you.
So contempt matters, serial number 1, Chokka Reddy.
For complainant,
In this matter, we have filed our compliance affidavit, my lords.
Endorsement has been issued, my lords, which is produced at,
So entries are restored.
please,
Entries are restored.
no, my lords, the grant has been cancelled, my lords, here. Way back, my lords, this land was granted to the complainant, but way back in the year 1978 itself, because there was a violation of grant condition, grant has been cancelled by the Assistant Commissioner and it has attained finality. Therefore, the entries have not been restored, my lords. Accordingly, an endorsement has been issued.
Land was granted, my lord, by violation of the grant conditions, he has sold the property, my lord. As initiated the proceedings before the Assistant Commissioner 1992. The land was restored and re-granted in favor of the petitioner, Assistant Commissioner. My lord, again, that order was challenged by the purchaser before the Deputy Commissioner. That appeal was dismissed in 1998. Till date, revenue entries has not been affected in favor of the loss of the grantee. He has approached the Tahsildar, thereafter filed the writ petition, issued the endorsement. Assistant Commissioner or Deputy Commissioner are in favor of the LRs of the grantee, my lord.
So you violated the condition of grant and sold it. What can be done? Your own
Violation of the grant, my lord, the Assistant Commissioner take cognizance and restore the land in favor of the the grantee, my lord.
challenge it if you want. The sale deed is voided.
Yes, my lord, sale deed is void.
Who by whom?
My lord, the grantee has executed the sale deed. My lord, thereafter, my lord, the their government said that immediately the grant was cancelled by violation of the conditions. My lord, they have not taken any action. 1992, the grantee was approached the Assistant Commissioner under the PTCL Act. 4 subclass 2, there is no permission and the grant conditions has violated. Assistant Commissioner has taken cognizance, sale deed is declared as void and to restore the position and re-grant the land. The purchasers, they have challenged the Assistant Commissioner order before the Deputy Commissioner. Deputy Commissioner appealed the order of the Assistant Commissioner. That is a 1998 order, my lord. Till date, revenue entries has not affected. Therefore, he has approached the Tahsildar for restore
As per our records, this is the record available. Let them produce the documents.
Produce those documents. Orders of the Assistant Commissioner and.
Yeah, I will produce, my lord.
Order of law on a single judge brought under the contempt jurisdiction, inter-alia provided that the subject under land, the entries in respect of subject under land should be restored in favor of the petitioner complainant inasmuch as the sale deed which was executed by the complainant has been voided by the purchaser. See, your order is passed when, madam?
Lords,
This is the second statement. But what he has filed is how can we do either?
When the copy of the order was obtained,
My lord, the assistant commissioner order and deputy commissioner order has not been produced.
copy of the order of this court were obtained.
This court, my lord, the annexure A, my lord,
Tell us, tell
writ petition 9371/21.
correct, when the certified copy was
That is an delay, my lord, delay application we have filed.
certified, you answer the query. The certified copy of the order of learning single judge, which is brought under contempt, was obtained on which date?
Sorry, my lord, produced, my lord. That is, my lord, in the office, my lord, my file was misplaced, that's why, my lord. I cannot answer that one. Original file, my lord, it was misplaced in my office.
Xerox copy is there.
Xerox copy, my lord, the CS copy I taken, my lord. CS copy I taken, my lord, today.
Right. Appointment, give this. This is the date, look at it. In our copy. Look at it. Is it correct?
1/7/2020, 2/7/20.
It is true.
It is.
It is true or not? That stamp is there, seal is there.
Yes, correct, my lord.
So on which date? Tell the date now. You have got the date. Tell the date.
1/7/2024 applied, 2/7/24 issued, my lord.
Oh, like 270. Give it back. 2/7/24, right?
20.
Now this is another set. See the date and tell us what is the date.
Eight 12/22, my lord, 13.
8/12.
8/12/22, my lord, applied.
So
13.
in first set, you are showing that you obtained the certified copy in 24 and filed the contempt petition in 24. In the second set, you are showing that you obtained the certified copy in 22 and filing the contempt petition in 24.
My lord,
So
the
are
delay
you,
application.
are you hoodwinking the court?
Sorry.
Are you deceiving the court? Are you withdrawing or we impose the cost of rule 1 lakh? What is this, Mr. Counsel? What is going on at your end?
Sorry, my lord, the second set of.
You decide you are withdrawing or you are imposing cost of 1 lakh. This is totally deceiving the court. And now you are saying that you don't have the copy, even the Xerox copy. In any case, this contempt petition is time barred, but this is an aspect, which glaring aspect, which will impose you the cost.
Sorry, my lord.
Decide right and now.
That, therefore, my lord,
Right and now you decide, are you withdrawing or we impose the cost for misleading the court? How could you do this?
Yes. Sorry, my lord, this is the
No,
mistake.
sorry. This is, we are not on for sorry. We are not against you personally.
My lord, the office clerk has committed a mistake, my lord.
Whatever it is.
That,
You know only the lawyer of the complainant.
recent
not-
applied copy has.
Now you decide right and now, Mr. Counsel.
Sorry, my lord, this is a mistake in our side.
You decide right and now. What do you want? Options are two. And third option is the order.
I will withdraw the petition. my lord.
Dismissed
Sorry.
as withdrawn.
Number 2.
Notice returnable on 20th February.
Number 3.
Same 20th February, notice returnable.
Number 4.
Same 20th February, notice returnable.
This PL matter, number 5.
Deleting
Anand.
respondent. Is
Okay.
permitted to delete
Appoint-
respondent number 3.
Appointment is made under what, which act?
Please, my lord.
Yes.
Article 338 of the Constitution, my lord. Commission for Scheduled Caste and Scheduled Tribe Commission has been formulated, and as far back as in the year 2002, the said commission is operating in the state of Karnataka, my lord. Now, my lord, for the last 2.5 years, my lord, the said commission has become
You want
functus.
to know the appointment is under which law? Like,
Running page number 26, I have also culled it out in my petition, my lord. Running page number 26.
26.
Number 2, volume 2.
Section 4. Terms of the office and conditions of service of the chairperson and members. Subject to the pleasure of the state government, the chairperson and every member shall hold office for a term not exceeding 3 years as may be specified by the state government. Now, my lord, the information is this, my lord, thousands of cases which have already been instituted before the said commission. They're all in an incognito mode now, my lord. There's no action in the said commission. That apart, my lord, new cases are being filed, and the employees are as such drawing their salaries, so on and so forth. So as such, the exchequer is already overburdened. Now it's been 2.5 years.
This is your decision only. Take notice.
I'll take note.
Notice. Notice returnable on 4th March.
Now, my lord, one submission. It has been 2.5 years since there is no chairperson. Now, the marginalized society, my lord, earlier what used to happen? They would directly approach the scheduled caste and scheduled tribe under 338. So there was speedy disposal of justice. Now, for the last 2.5 years, since there is no chairperson, the employees are also being paid there.
Last 2.5.
Please, my lord.
2.5 years.
Yes, 2.5 years, my lord. So that is why I have just made an interim prayer, my lord. I don't know whether I'm right in making this prayer. However, I have sought for an appointment, intermediary appointment of a chairperson.
Grievance in this public interest petition is that the chairperson to the Scheduled Caste and Scheduled Tribe Commission
Commission, please.
has not been appointed by the state government since last, and that the post is vacant since last 2.5 years. Paragraph, notice returnable on 2.5 years, full stop. Then add. Section 3 of the Karnataka State Commission for the Scheduled Caste and Scheduled Tribes Act 2002 provides for constitution of the Commission for the Scheduled Caste and Scheduled Tribes, and also contemplates the appointment of chairperson and members thereof. Section 4 is about the term of office of the conditions of service of the chairperson and members. It is incumbent on part of the state government to act to ensure that the post does not remain vacant for long, and that the Commission for Scheduled Castes and Scheduled Tribes remains functional. Paragraph, it was submitted that the post is not filled since last 2.5 years. Paragraph, notice returnable on 4th March.
Obliged.
A shorter date.
They will have, say,
No, what is, the only thing I'm not trying to urge any additional grounds here, my lord. The only thing is that, my lord, already about, according to my knowledge, 1 lakh cases are pending. So I've said thousands of cases. Now what is happening? New cases are being filed, and the earlier ones also are remaining pending.
17th February.
Obliged.
By that time, let them come up with a solution for it.
That is why
Yes.
notice.
Great.
So look into the matter.
I'll make Mandamus.
Which? This is. So before that, at the outset, as requested in the as per the memo dated 20th/1/24, and respondent number 2 shall stand deleted from the array of the respondents. Then regular order is prescribed.
Green bench matter, seal number 6.
Lots in this matter, my lords, the 2016 amendment to the Karnataka minor mineral concession rules
Notice,
was challenged. No, my lords, interim order has been granted in similar matters, my lords, by this honorable court.
but you are not prayed for.
I have, my lords.
Where is? You teach.
I have, my lords, I'm sorry. 105 is the similar, page 105 is the similar.
Granted by another court.
Yes, this honorable court. In all matters, it's been granted because the matter is pending before the
And I'm,
honorable apex court.
Notice returnable on. Notice to be heard with.
And page 105, my lords, 10704 of 2022. There are a batch of matters, my lords. This is one of them. 105, my lords, page 10.
10704
Yes, yes, please.
of 2022. In which the similar challenge to the validity of Rule 32 of
I mean, on
Karnataka
came
minor
and
min-
the,
2016.
Karnataka minor mineral concession into bracket amendment, Rules 2016 is another challenge. It could be submitted undisputedly that in the identical case, this honorable court has granted interim relief. Therefore, same terms.
Same, my lords. The operative portion, my lords, is at page 107, last para, my lords. Your lordships have, if we have all the clearances and statutory certificates, my lords, your lordships have permitted us to continue quarrying. On payment of royalty.
In that view, the following interim order shall operate as is granted in the other petitions. So quote this as an interim measure, page 107. We just quote it. Environment clearance. मिल जाएगी.
Great, my lords.
System number 7. Mr. Ravindra Gajanan Pillai.
You all other clearances.
Yes, my lords. I have produced all the clearances
The
also.
learned advocate Ms. So-and-so of the petitioner makes a statement that petitioner has all other petitioner is granted all other clearances by the competent authority.
Yes, my lords.
In that view, the following interim order shall operate, which is granted in the other matter, then quote.
Annexure C and D have produced, my lords.
System number 7. Mr. Ravindra Gajanan Pillai.
Please, my lords.
It is only an interim order of the NGT.
Yes.
Yes, my lord, but
Whatever will happen after the final order. Why
Yes,
you
ma'am.
file petition?
because the order passed by NGT has already been stayed by my lords.
Then it is interim order.
Yes.
Yes, but subject to the results of that, I am abiding, my lords. Several query leases are operating, my lords.
We don't know the status and the page and everything.
But in the meantime, respondent number 6 and 7.
You can go before NGT. You are there in the before.
No, I am not before NGT, my lords. Because I am granted a query lease by senior geologist who is the competent authority. I have submitted an application seeking grant of environment clearance certificate. Knowing fully well passing of the interim order by my lords, the EC committee has kept the matter in abeyance, which is impermissible under law. When an EC application is filed, as per law, within 45 days, it should be disposed, either this way or that way. Or even under the rules, also 90 days is the maximum cap that can take it. But here it is more than 1.5 years, my lords. The matter is kept pending for no legal or valid reasons, my lord.
What is your stand?
My lord, I'll seek instructions and make my submissions. It's coming up for the My
first
my
time.
prayer is to respond number 6 and 7, my lords, not to the learned government advocates council, my lords. It is 6th and 7th respondents.
Then notice will have to go to them, ma'am.
Beg your pardon?
Notice.
Please, my lord.
Lord, let notice go to them. I'll make a statement.
Now you tell us that what is the stage of the NGT matter?
NGT, because survey number 199 acres runs into more than 1,000 acres.
No, stage of the.
Stage, no, by virtue of my lord's orders, which I have produced at page number 30, my lords, the matter is.
No, stage of this red petition, 19135.
Yes, my lords.
It is before this bench? No.
No, this is pending. It is kept pending.
Before which bench? This bench?
Yes, my lords. Yes, my lords. I have produced the order at page number 28, Annexure B, my lords. But at page number 30, at serial number 14, the order portion appears, my lords. Shall I read the relevant portion, my lords? In the middle portion, at point number 14.
In the meantime, no.
Yes, by way of an interim order, the order dated 25/7/2023 made by the National Green Tribunal in OA number 85/21 is stayed till next date of hearing. And from that day onwards till today, it is continuing, my lords. And almost all query leases in that survey number are now functional without any disturbances.
Well, I take instruction.
My lord, I may look into this and make my submission.
Notice returnable on. We'll keep it little earlier,
Yes,
11th February.
oblige me.
But notice to respond number 6 and 7.
All.
Please, my lords.
11.
This is number 8.
Please, my lords. Herein, I am seeking consideration of my representation, my lords. I applied way back in the year 2015. And revenue NOC is obtained, technical report is obtained, only forest report was not obtained despite making a request by the competent authority senior judge for on 3 earlier occasions. On the 4th occasion, the DCF gives a different opinion, contrary to the opinion given by the range forest officer and assistant conservator of forest. And only on a technical issue that Rule 41(2) of Karnataka forest rules is applicable. But that is applicable only in respect of reserved forest, maintaining a distance of 100 meters from the boundary of the reserved forest. This has not been declared as a reserved forest. It is only NEB block forest. And adjoining to that also it can be granted.
Notice returnable.
Please, my lords.
Same date, 12th of February.
Please, my lords.
So 9 is urgent, still number 10.
My lords, in item number 10, my lords, I beg leave to appear. May I just, my lords, recite the facts, my lords, in just 2 minutes. My lords, if I may. The subject matter, my lords, of this petition is about 78 acres of land, my lords, in Whitefield, which is in Bangalore. Broadly, my lords, valued in about 5,000 crores. This land, my lords, was allotted by the KIADB on a lease cum sale basis
to the respondent number 2.
You are Mr. Which matter? Which
My lords,
application?
I am appearing, my lords, for Manu Prabhakar Kulkarni in item number 10. There is, my lords, a connected matter, my lords, in 10.1.
In both appeals you are appearing?
My lord, I appear in the connected. Yes, we are appearing together, my lord.
Kumar appears in 10.1.
I appear for respondent number 2, my lord, in both the appeals.
My lords, may I?
Now, who is the appellant?
The appellant, my lords, is a person claiming to be a shareholder in the second respondent, who, my lords, is the allottee of the land. The appellant has filed a suit, my lords, for a declaration of title vis-a-vis his shareholding. That suit is pending, my lords. None of that dispute is being, my lords, agitated in the writ petition. In fact, I had paid money for 50% of the shares in the second respondent, who has got the allotment of 70 acres from KADB. Inter se between me and the shareholder who is in control, there is a civil suit pending. KADB, my lords, in fact, as my pleadings indicate, my lords, KADB's pleadings are also available, my lords, in one other suit. I will place that before your lordships. The writ petition is filed, my lords, only vis-a-vis impingement of some of the conditions of the allotment of land between the KIDB and the second respondent company. In 2 minutes, I'll place the facts, my lords, before your lordship looks at any papers.
Yes. Yes.
The dispute was fairly simple, my lords. Whether I was right or wrong, I filed a writ petition bringing to the notice of the High Court that 8 charges are created on this public property and about 1,000 crores of debt are raised on this public property, and KIDB has not issued NOCs for 8 out of the 10 debts. Therefore, we indicated that without the NOC of the KIDB, how is a public asset being mortgaged to private banks and money being taken away by a private entity? My locus was raised, my lords, as an objection in that writ petition. The learned single judge, my lords, when admitting the petition and then considering it, held that given the gravity of the matter that is brought before court, my locus pales into insignificance, and therefore, my lords, issued a direction that there must be, my lords, an investigation conducted by the KIDB, and KIDB, my lords, must indicate what is the outcome. That was, my lords, brought up in appeal before your lordships. In fact, before a bench of my lord the Chief Justice in a different combination. My lord the Chief Justice, my lords, considered the appeal which was filed by the private petitioner, who, my lords, was the allottee. And my lords continued to hold that KIDB should conduct an inquiry, but did not issue a mandamus because KIDB undertook that it is conducting an inquiry. Therefore, my lords directed that in the light of the undertaking, a mandamus is not necessary. As regards my locus, my lords, to file a writ petition, My lord, the Chief Justice in a different combination did not, my lords, observe that I have no locus. If I had no locus, my lords, the writ appeal should have been allowed and the writ petition should have been dismissed. In fact, my lord said that because I'm a private party, I don't have to participate in the KDB inquiry. Let KDB inquire against the LOT. I had no objections to it. My lords also reserved all our rights, my lords, subsequent to that inquiry. The matter went back, my lords, to the KDB. Before the KDB, my lords, a section 34.1, 34.2 and a 34.3 notice was issued. In the 34.1 notice, about multiple violations were identified. Two of the violations predominantly were that one, you have changed the shareholding of the company. Please leave it aside. But primary violation is you have created 8 charges. I, KDB, have issued NOC only for 2 charges. You have to therefore make good that violation. After holding an inquiry, my lords, KDB reserves this matter for orders, my lords, in March of 2024. And on 3rd of September 2024, pronounces, my lords, a cryptic 1-paragraph order in which the order says, I, KDB, I am now giving you the LOT a further period of 2 years to develop the property. And, my lords, thereafter adds reasons to that order. A span of, my lords, 7 days thereafter, on 10/7/2024, in the reasons, my lords, they simply turn up and say that there are 8 charges. I have only given NOC to 2 charges. About 1,000 crores is taken as debt. But because you, the LOT, you are now telling me that you will use this money for development and you have undertaken the task of clearing the property and appointing a security guard there. I am condoning, not even condoning it. I'm simply giving you 2 more years. My lords, when that order was passed by the KDB, I, my lords, go back to the single judge, my lords, by virtue of a writ petition, saying that the KDB has done nothing except to parrot the observations and, my lords, simply by an order condone. That order, my lords, is a cryptic order. Reasons are attributed 7 days thereafter, which is impermissible. Therefore, illegalities are writ large. The learned single judge, my lords, dismissed my writ petition not on the merits of whether KDB is right. The learned single judge simply says, you, Mr. Puvaya, you had filed a writ petition that went up in writ appeal. Your locus was protected in the writ petition, but the writ appellate court has held that you don't have locus. Therefore, in the light of the observation of the writ appellate court, you are now divested of locus and therefore your writ petition is not maintainable. My lords, I am simply on appeal over that order, my lords. If my locus was right for the first writ petition and for the writ appeal before, my lords, it couldn't be, my lords, that my locus is divested for the second writ petition where I challenge the order on merits. And permit me to show.
Project is being developed by you.
Yes, my lord.
Project is being developed by Mr.
After
Raghavan.
my learned friend has finished, I will show your lordships the findings recorded by the learned single judge.
No,
This,
the order only provides for extension of.
yes, and the appellant before your lordships, my lord, my learned friend started by saying, your lordship asked my learned friend a question. Who are you? And my learned friend said, my lord, I am a shareholder. That is a wrong statement.
I am a disputed shareholder
I'm sorry,
in suit.
they are not even shareholders.
My lords, I'll clarify that, my lords. Let me present my case.
Of course, you will. I'm not saying no.
My lords, therefore, please, my lords, permit me to show 2 directions of the learned single judge. My lord's direction in the writ appeal proceedings and, my lords, the final finding in the impugned order, my lords, against me.
One second.
Can we refer this matter to mediation? You both can you settle down?
But I have to take
I think
instructions.
take a try.
I have to take instructions, my lord, on whether that shareholders dispute can be resolved. In fact,
Mr.
I want
Poya, in the larger interest, both of you can settle, I suppose.
My lords, I am most willing, my lords.
I'm sorry.
My lords, may I make? I'm
My
sorry.
lord, I tell you not, my lord,
Sorry.
what happened was.
May I just
the-
make one statement, sir, with Mr. Raghavan's permission, my lords? I'm sorry. I have this problem of being remote. Please pardon me, my lords, on this.
My lord, no, my lord, I understand, my lord.
I just make one submission.
It is Monday, my lord, and we don't expect my learned friend to be here.
My lords, the only
My lord, I must say, my lord, I have a vested interest in my learned friend's prosperity, my lord.
No, I did not want to
And
put
they are
my
the-
learned
and-
friend's leg because
and-
I'm on the same side, but
And we are very proud of the fact, my lord, that he is in so much of demand in Delhi.
Malats, I'm grateful. We all learned the law, Malats, at Mr. Raghavan.
We were just asking that which is the essence of, what is the essence of
My
the?
lord, the essence of the dispute is he claims, my lord, in 2010, no? In 2006, he says that there was an oral agreement to convey certain shares in my company by the erstwhile shareholders to him. And therefore, today, the sale of the shares by those erstwhile shareholders in favor of somebody else was wrong. And he files a suit, my lord, not for specific performance. He files a suit for declaration. And in that, my lord, he sought for an injunction, saying that nothing must be done with respect to these shares. Injunction was refused. Matter was carried up in appeal before this court. Appeal dismissed in the commercial side.
The court said.
my
that
learned
you should-
esteemed friend may not be entirely
His
correct.
lordship
He may
asked-
not be entirely correct. I'll point it out.
1 minute, 1 minute. Let me, his lordship ask,
Really,
let me
really.
answer. I may be
Please
wrong,
point
you
out,
can
please
correct
point
me.
The order says that subject to withdrawal of that suit. Is it? The order which was under challenge in the writ petition. Plan subject to withdrawal.
No,
of-
I'm sorry. That's a separate
No,
suit.
my lord,
That
that's a
was a
separate
suit filed
suit.
by them against KAD.
No, my lord. What happened?
I'll clarify that, my
The
lord.
commercial
Yeah.
suit has been filed, which is pending. He claims, my lord, to be not a shareholder, to be an oral agreement holder with respect to sale of certain shares by erstwhile shareholders who have already sold the shares, they have gone, they have taken the money, everything is over. Now, my lord, because he filed an application for injunction.
Factum of oral agreement is admitted fact.
My lord,
Factum of oral agreement.
which agreement, my lord? No, seriously disputed. We said the oral agreement, nothing was there. And what happened, my lord, is this. Of course, my lord, is here, and he,
See, with all due respect,
my lord,
see, dispute between two private individuals, you have dragged the state authorities.
I didn't, my lord, they.
Whatever. It can only result in loss to both of you. I think if better sense prevails between you both, it is better to go to mediation, settle the matter. You both know what is the reality. It's after all a financial transaction. Be true to yourself and settle the transaction. I think that will settle all your disputes, because I can see multiple disputes over here, subject to you people.
I will take instructions, my lord. I'm not able to say right away, because, my lord, there is a commercial suit that.
No, Malats, may I just,
filed,
Mr. Raghavan may
injunction
permit me.
application dismissed. They filed a commercial appeal dismissed. Then writ petition was filed first time, my lord. An order was passed in the writ petition by the learned single judge in the earlier round. Writ appeal filed, order modified. Then, my lord, second writ petition now filed.
My lord,
And now, my lord, we are before your lordships.
my esteemed senior
Let's
friend
see
got a
if-
little carried away, not entirely correct.
Let's
Let me
see
point
if
out.
petitioner, are you agreeable for mediation?
My lord, mediation in principle, I'll never say no to, but that's besides the point. Let me just clarify a few facts. I have in fact asserted.
If you
that-
are agreeing for mediation, there is no point in hearing the matter.
It is an objective way to look at the controversy, to refer it to mediation, subject to you.
Lord, we are agreeable, my lord, for
Malats,
mediation.
please give me 30 seconds. I'm upfront, I'm indicating I'm agreeable for mediation. Please give me 30 seconds, my lords, to dispel this whole prejudice that has been, my lords,
Yes.
attempted to be caused. In 2006, my lords, I paid 9.5 crores.
Take instructions.
That money is received by my lords. My lords, I'll be candid. In fact, my lord, Justice Arun, my lords, will even recognize these are large builders in the city, my lords. I'll be in call candor, I'll place the facts. There is a Reddy Veerana and a Jitu Virvani fighting over, my lords, rights.
We don't look at the parties, Mr.
No, my
Counsel.
lords, no, these are developers, my lords. That's why I'm just saying, my lords, therefore, there is nothing to hide,
So
my
the
lords. I've come
reference
in.
of a large builder is thoroughly irrelevant.
No, my lords, I'm the
Simple
petitioner.
answer is, no, we don't like to. listen
One
to
fact, my lords, please permit me, just 30 seconds. I'm not, my lords, I'm Reddy
Common man or
Veerana.
builder, we don't care, Mr. Counsel.
I understand. I'm sorry, my lords, I didn't mean it.
You
that way.
decide whether you want to go to mediation or no irrelevant
will.
argument.
I will go.
Yes, I
I'm
do not
sorry.
entertain such arguments.
I'm sorry, my lords. It was my mistake to bring the name. I apologize.
Very
That was
sorry,
not
I'm
my
very
intent.
touchy about all these things. This is
I understand, my
court of law,
lords.
be professional, entirely professional.
I'm so sorry about it. My lords, in the dispute, my lords, between two shareholders, this land, my lords, being allotted to the company, my lords, is not being questioned to say the land should go away. Because there were some disputes within, my lords, the land being mortgaged to various banks, this writ petition was filed. What is my intent, my lords? My
No,
intent is
brother
not to
rightly
take the
saying
land
whether
away.
you're opting for mediation or not. If you're not opting, we'll proceed with the matter. If you're opting, we'll send to the mediation center. Pure and simple.
But we are opting for mediation, my lord. I have instructions now.
In course of the
Your
hearing,
Lordship, but please bear with me for a
I
minute.
will take.
Please bear with
instructions,
me
my
for
lord.
1 minute.
let Mr. Raghavan take instruction.
No difficulty, my lord, but please bear with me for 1 minute. I just wanted to make 3 short points. I'll just make them, my lord, and then I'll leave it to you.
You are for?
I appear for the appellant along with my esteemed friend, Mrs. Puvaya. My lord, my first submission is that I have in fact asserted that I'm a shareholder, so my esteemed friend may not have been correct in saying that I'm not even a shareholder. Second, injunction was refused is correct, but in the appeal, commercial appeal, I was given some protection and the appeal came to be disposed of, not dismissed. That is again may not be factually correct. Third, he applies for rejection of the plaint, dismissed. He applies for summary judgment for dismissal, dismissed. So for him to say that there is no case made out whatsoever is wrong. Then, my lord, on the facts of the writ petition and the writ appeal, my submission is as follows. The first contention that was raised was that there have been mass borrowings against public land because the land has not yet been transferred to them. If I am not a shareholder, he also is not an owner today. He is only an allottee. So much in the much the same way, that inquiry on 1 week, my lord, the KADB would say that there are grave violations and issue a show cause notice to him and assert that in another suit filed by him for specific performance against KADB. The very following week, it gives him a carte blanche and says it's okay, doesn't matter, go ahead. Now, the point here is that the impugned order is passed on 3rd September, but the reasons are provided on 10th September. This point has not been addressed by the learned single judge at all. More importantly, my lord, right through, we had the protection.
Who has provided reasons late? The author?
KADB, the impugned order before the learned single judge, KADB, my lord, the officer would pass an order saying no difficulty and supply reasons later.
Actually
That is something that the learned single judge does not even advert to.
Factually incorrect, my lord. Here is the case, my lord.
How does that fact matter here?
My lord, the reason it matters is that was subject matter before the learned single judge, my lord. That was subject matter before the learned single judge. Be that as it may, my lord, since your lordship asked the question, we are ready for mediation, no quarrel about it. But I just want to bring to your lordship's notice, right through, we've had the protection that they would not alienate the lands or further encumber. Let that protection be continued, my lord, is a show of good faith. That's the only thing I would submit. Right through the learned single judge's order, division bench order.
Essentially, you are the petitioner.
Yes.
And I want your lordship in response to my learned friend's submission that there should be a protection. Please see the findings recorded by the learned single judge.
No, we'll not disclose our mind because we have already asked you to whether you are opting for it.
But I'll take
My lord, from my side,
take
the answer is
You
yes.
say something, either of you will say no,
I
will
know.
not be.
I'll take it.
One
But I'll
submission,
take-
my lord.
My lord,
One
the
second.
answer
I'll take
from me is, my
instructions,
lord,
my lord,
I
and
will
come back
go
to your
for
lordship's, my
mediation
lord. I have
and I
some
will go
thoughts.
for mediation without conditions, my lord.
But
I will go for mediation for
I
closure.
have some thoughts. I have some thoughts, my lord, which I want to share with my learned friend and the clients, and then place it before your lordships, my lord, so that it is appropriate. I do it that way.
No, we'll hear. This is all in preliminary. Whatever you decide, we'll do.
Yeah, your lordships may just
Just one
adjourn it by a
submission
week,
for
my
your
lord, and
lordship,
then
kind
I come back.
Yes, Mr.
My lord,
Advocate General.
Mr. Puva's client and Mr. Ragan's case have a dispute, my lord. They're dragging the state and the KADB into this as if ultimately, my lord, we have given both the appellant and the respondent certain benefit. Whoever wins, we are not concerned. To settle their score, this case has been thought to be brought us into this, my lord. It's basically a suit for recovery being fought by two people, my lord.
In fact, my learned friend appearing for the KIDB is right, my lord. By this order, the company is benefited if ultimately my learned friend Sajjan Poya and Mr. Nandakumar's clients succeed. They will also benefit. I don't understand why the company should be deprived of this property. This is only for the purpose of putting pressure on us.
We have never asked for deprivation of property.
No, that's a prayer in the writ petition.
I think.
Let me show to your lordship the prayer in the writ petition.
Anyway.
In fact, they should be happy.
My lord,
They-
prayer is
I would be happy, but you discharge the loan. Then I will be very happy.
prayer is to cleanse the
It's been
property
done
of
already.
debt.
Don't worry. It has already been done. I'm going to make a
We'll point
submission
out
for that.
how. We'll point out how.
My
That
lords,
is
from
very
our end, we are
not
willing
brought
to
to
go
the
for
court's
mediation,
notice.
my lords. Your lordships may direct parties to go to mediation, my lords, then it is their fate in mediation.
As a shareholder, he was promised something.
My lord, he is not even a shareholder. Nothing was promised to him. Kindly see the order passed by the trial court. which has not been disturbed by this.
Kindly see
honorable
what was
court.
passed by
I
the
mean,
division bench
I
of this court.
will,
The
I
learned friend
will.
should point that out.
I will point it. Of course I will. If you give me a chance, I will point out everything.
Alala,
How can I
then
not?
once the order is no longer
One
one
minute,
of the
one-
trial
I
court, you should
will do
point out the division bench's order, sir.
I will 100% I will do it.
Trial court order itta velu.
I mean, what I will do in the one is different. I know that his lordship knows that.
Who has instituted civil suit?
They,
If you succeed in the civil suit.
exactly.
I'm sorry, my lord.
Exactly.
They are the beneficiary. If they succeed in the civil
Beneficiary. If they
Both-
succeed
both
in
are
the civil
beneficiaries.
It
suit,
is not as
Both
simple.
are
Let me not answer the learned advocate general's query.
They're just loudly thinking.
my lord, I told you, if I show to your lordships, my lord, the order passed by the commercial court and the order passed by this honorable court, which the learned rightly says I should point out, everything will be clear.
If they succeed in this suit, you will give up this appeal?
My lord, no, there is a reason for
Oh,
it.
they
There is
will,
a
my
reason
lord,
for
they
it.
will.
I'll point out why.
My lords, I'll-
1 minute.
In fact, my lord, the Chief Justice, my lords, asked a pointed question and that
Yes.
is correct. My lords, if the suit, if let us assume, my lords, I win the suit, which means, my
Yes.
lords, my 50% shareholding in the company is therefore untrammeled.
Yes.
Nonetheless, my lords, this proceedings continues because the
Yes.
land, my lords, must be cleared of charges that have been
Charges, that is the
created
point.
illegally.
They've created
There is
charges
1,000
illegally. That is the whole
crores.
grievance.
This
1,000
is,
crores of debt
this
on the
is-
property.
Yes.
my
how
lord.
does it affect them?
After succeeding in this suit.
My lord, no.
Fight it out.
Let us-
Irrespective of success in
Let
the
us,
suit.
let us assume,
Yes.
after succeeding in the suit,
Yes.
your locus will be diluted.
No, my lord, it would be strengthened further. I'll point out why. I'll tell you, lordships, what has happened. Here is a case where,
What we are trying to convey is.
Please.
that This is an issue which should be sorted out at mediation.
I bowed
That
down,
is
my lord.
correct.
Straight away, my answer to your lordship's query on mediation is yes. I have instructions also. The answer is yes. We are
That
ready
is
for it.
correct.
I
my
will
lord.
take instructions, my lord, get
This
back.
is a
to you.
fit case for settling between them, my lords.
The lordships may give us a week or 10 days time and I'll get back.
Let
My
the
lords, why
protection
week
that
or
we
10
had
days,
not
my lords,
be
to
continued.
mediate?
That I'm serious
My lord,
objection.
please see what had happened. 1 minute, let me point it out. Let me
Of
point
course
it
you
out.
can.
Yeah, but then don't take away my right of pointing out. That's all
No,
I'm
sir,
saying.
I will not.
My lord, we had protection before the learned single judge. In the writ appeal, my lord, we had protection. When the writ appeal in the first round came to be disposed of, my esteemed friend made a statement that he would not alienate or encumber further till the KADB decides.
Yes.
Today, the KADB is
Yes.
decided and that's set in challenge.
What he will not alienate?
Let them not do it. That's all I'm saying.
Land.
No, my lord,
Land.
I tell you, lordships, now, my lord, the question is this.
No, what did you, what is your statement?
My lord, this only order that was passed was that we will not create any alienation or charge without the permission of the KADB. That stands even today. Where is the question?
Let him make that statement. No
My lord,
difficulty.
now, the question, my lord, is this now. Today, there is a category, this is very serious finding that has been recorded by the learned single judge. And I want to point out to your lordships, the learned single judge has said that they are taking unfair means in order to fight their private rights. My lord, that's a serious finding against them.
You can't alienate when you are going to take instruction.
It's not question of alienation, my lord. All that, there was no question of saying no alienation. That's not what the learned division bench said. All that was said was, don't do it without permission of KADB. The allotment order itself says that I can't alienate it without their permission.
Let him make
What
that
is
statement.
the-
My lord, I'll read the statement made before the learned, before this court, my lord, in the previous round. It reads, my esteemed friend's statement was,
Yes.
learned senior counsel appearing for the appellant, that was him then, on instructions made a statement before this court that till the inquiry is completed by the board, appellant will not create any charge without the permission of the board. This statement is taken as an undertaking to this court.
And
That-
now the
1 second, sir, let me complete. My lord, my submission is, today that inquiry is completed, but that is set in challenge before your lordship. So till such time, the next date of hearing, let him, my lord, continue.
No,
that
now I
statement.
tell you,
That's all
lordship.
I'm
Now,
saying.
if my learned friend has finished, I tell you, lordship, what's happened. Inquiry was completed. Inquiry said that the time granted is extended. Challenge was made. Challenge rejected. I ask myself, my lord, is not what was said in the first round of litigation when the inquiry itself had not commenced, completely diluted by the fact that the inquiry is in my favor, learned single judge's order in my favor? My lord, in spite of it, the allotment order in favor of my client itself says that I cannot create a charge without the consent of the KADB. Where is the question?
So what is
No,
his
no,
hesitation in
let
making
me-
the statement?
If you don't mind, I mean, every time we can't have this, please. Let me complete my submission. I have not completed. Therefore, my lord, I say that we will, of course, abide by the terms of the allotment in our favor. Where is the question? To rely upon that statement, my lord, is not appropriate.
Terms of allotment also said they should not create charge at all.
Let me complete so that I mean, please say that we will abide by the terms of the allotment. Where is the question? Whatever is contained, there will happen.
Then we are at a stage when both of you are.
My lord, therefore, this interim order is not, my lord, warranted for the simple reason that this will create a problem, my lord. It will come in the way of my clients consenting to mediation.
Forget
Let
the-
us not do it, my lord.
Kindly forget both of you, the interim order of learner single.
Yes.
Now we are at a stage when one of you are taking instructions about going to mediation.
Yes. Correct, my lord.
So there should be no resilement from any status.
That's my submission.
My lord, all that I would say, my lord, at this point of time is we will abide by whatever is the terms of allotment. I cannot do anything more. Allotment terms itself says that I cannot create any alienation or charge without the consent of the KIDB. I will do it. My lord, reason is this, my lord.
Shall we
If my
record?
learned friends are serious about a mediation, then, my lord, if there is an order like this, then, my lord, there will be a resistance from my client.
No, I'm only
But
let
you
my
will
learned
say
friend
no,
make
but
a without
that's
prejudice
not-
statement. I have no difficulty.
You use terms of allotment, no difficulty. Terms of allotment, how can I
No,
decide?
because you already violated the terms of
I'm
allotment.
giving a statement to the court. Terms of allotment, I will abide.
You already haven't. That's why I'm
Okay,
saying don't
all
create
right.
charge. That's
Yeah,
what's the
that-
difficulty.
You are saying it, I am saying no. That's the end of it. Not if there is any,
In course of the hearing, when the senior counsels for the parties were asked whether, having regard to the nature of the dispute involved in this appeal, the parties would opt to undergo process of mediation to resolve the dispute. From a learned senior advocate, Mr. Raghavan, for the respondent number 2.
Yes.
Requested the court to grant 10 days time to take instructions from the respondent number 2 in this regard. Full stop. While taking time, he further made a statement that until the next date and subject to further orders, respondent number 2 shall abide by the terms and conditions grant, which includes that the respondent grantee shall not alienate the subject.
without the permission of the KIDB.
Please.
Shall not alienate the subject matter land
Correct.
without the permission of the Karnataka Industrial Development Board.
Not alienate or create charge because
Alienate
No,
or
no,
create.
Great.
No, we'll, your lordships may
No.
put whatever is
We-
contained in the, in terms of allotment itself.
You can't have the cake and not cut it too.
My lord, I'm sorry.
You can't have both ways.
No, my lord, I am saying whatever is the terms of allotment, I will abide so that I don't want, my lord, words to be put in at the instance of my learned friend.
Pointing out from
No,
the
but-
order.
Sir, let me complete, sir, if you don't mind.
By all-
All that I'm saying is, let us not modify by adding any words into the terms of allotment. Whatever is contained there, I will obey.
Or we say that whatever status was prevalent before learner single, that.
No, my lord, that, my lord, I will not agree. That I will not, then, my lord, the whole difficulty is if there is any such order, then it will come in the way of my client concerning, he'll say, let me fight it out, whatever is result, it will happen. My lord, that doesn't serve the cause of anybody. Therefore, my lord, I am saying that whatever is the terms of allotment, I will abide by it. Your lordships may, whatever is there, I will abide by it.
Is it okay, Mr.?
It should be.
But
my
yes,
lord, I
but
can't-
all I'm submitting is including this, that's all,
No,
because
no,
he was supposed not to change the nature of the company, he's apparently
No,
changed.
no.
I don't want to get into those controversies today if we're going into mediation. Your lordship should kindly say, including not to alienate or create charge, that's all.
What
I'm
is terms of
submitting.
allotment? Just 1 minute, my lord.
I'll
We're
read
looking
it
at the
out,
terms of
my lord.
allotment.
I'll read it out to your lordship.
We're just looking at the terms of allotment. Where is the terms of allotment? No, terms of allotment.
My lords, at page number 312, the terms of allotment say
Thank you, sir, thank you.
I was-
that
That's what
they
we're also
will
looking
not create any mortgage, etc., without obtaining consent in writing from
My
KIDB.
lord, we will abide by whatever is contained, my lord.
I'll read that.
in-
I'll read that,
Just
ma'am.
1 minute, sir. In the lease cum sale agreement dated 7th of June 2007, and which includes, my lord, a clause which says, and I'll read it out for your lordships, my lord.
Where is that?
I tell your lordships, my lord.
Page
My lord,
300.
please
My
come
lord,
to
please look at page
312, my lords.
312.
Page number.
My lord, thank
Only
you,
give the
thank
page
you,
number.
thank you.
I'll read those two, my lords. The lessee may mortgage right to create interest
Not
in the
whatever is
property
contained, there we will do. That's all.
after obtaining consent in writing from the lessor, which is, my lords, the KIDB. And 12, my lords, the lessee shall not change
12,
the
yes.
constitution
Correct.
status of the firm or company, etc.
In so far as 12 is concerned, there is no prayer. They already, that's
No,
beyond
I'm
the
reading the
scope of the
conditions, my
petition.
lords.
So
My lord,
then is there an
all that I'm
intention?
saying is, my lord, please see 11B at page 312. No, that,
Shall abide by the term of the vote allotment.
my lord, it is, my lord, the lease cum sale agreement dated
What is that
7,
It is called
it is come sealed, my lord, it starts at page 305.
terms of the lease cum sale agreement, including what is contemplated
11B,
in paragraph 11.
B.
B.
Grateful.
B and 12.
No, that I object.
No, then he's saying that he's going to violate.
Tell your lordship.
Is he saying he's going to
One
violate?
minute. Then, my lord, we'll argue it out. Then we'll argue it out straight away. I have no objection.
You said including.
It's all right.
My lord, if it is,
I'm
if
only-
my learned friend.
I'm only pointing out something anyway. I leave it to you.
Of the, all
Well,
the terms of lease cum sale.
That's all, my lord. That's all.
The whole lead, my lord.
Including 11.
Yes, my lord. And a reason
I'm
is this, my
satisfied
lord.
with
I tell you,
I'm
lord.
satisfied with that.
That is a,
Sir, I'm saying.
11B.
my lord, there is a twist in the tail in the submission of my learned friend. I tell you, lordship, what it is if necessary.
Yes, we'll point out all that you
Then we'll
also
argue it out. No
done.
problem. Right away, I'm ready.
Around mediation. And he wasn't at that
I have not agreed to it.
Fair enough.
My lord, let them, your lordship may record that they are agreeable to it.
Absolutely no problem.
Correct. It's not recorded.
No.
No, he's not recorded. He asked. Yes, sir. No, your lordship may record that they have no objection for mediation. So that I can tell my clients that.
No, let it be both ways, my lords. We have indicated in court.
This is going back.
Not going back. I have indicated in court, my lords, as counsel, let Mr. Raghavan come back. It can't be one part of
My
the
lord,
order. my
are
lords,
they
that an order
agreeable or
being
not?
misread.
They have told your lordship that they are agreeable. Your
I
lordship
am
may record that.
consenting.
Now he can't go back on what he has said.
My lords have recorded that we are willing, my lords. I don't know why Mr. Raghavan should be so touchy
No,
about
it's not
it.
recorded, sir. It's not recorded.
Mr. Raghavan, we as counsel are indicating that we are willing to go to arbitration.
It should be recorded. He was saying.
So he is right. We'll say nothing.
Yes,
We'll
my
just
lord.
take instructions.
Then I take that one. Then which means then I take it that it is open for them to go back also. Is that so, my lord?
My lords, we are not going back. We are here. I don't know why Mr. Raghavan, my lords.
Then let it be recorded so that I can tell my client they are agreeable. What do you say?
So you want something to be recorded?
No, my lord, whatever your lordships are recorded is fine by us. I don't know my
Fine by us, my lord.
No,
But
I
Mr.
will
Raghavan
tell your lordships what the
You
problem.
have subtext
No,
and footnotes
one-
and.
1 minute. I will tell you lordships what I am saying. Now, my lord, they indicated to your lordship that they are willing to go for mediation.
Yes.
I was forthright in telling your lordships, my lord, that I need to take instructions. Yes or no, I don't know. All that, your lordships have recorded my submission that I need to take instructions. All that I am requesting is that their submission that they are agreeable to go to mediation may be recorded so that I can tell my client, look, they are agreeable. What do you say? Otherwise, do I go back and tell my client everything is open? They are also not agreeable. I don't know whether they will agree or not. You also tell me.
My lord,
What
if
do I
my
need to
learned
tell the
friend is
client?
having such hesitation.
No, my
for
lords
this-
may please record. My lords may please record.
My lord,
I am willing.
just one minute.
Impliedly, it means
No,
that.
I am saying, my lord, in court order, let it not be an implication. Let it be, if they are say.
I have no objection in your lordship recording that I am agreeable to mediation when it fell from your lordship.
Saying,
If my learned friend is so particular about what the terms of reference to mediation should
We
be,
don't know.
God
We
forbid what
we
will
don't
happen in
know. We don't
mediation.
and my lord,
Let us come with an open
no.
mind,
My learned
not
friend
like
is-
this.
My learned friend has a point there. That is why I told your lordships, my lord, I have some thoughts on the mediation as to how to go about it, how to handle it. I will get back after I get instructions.
Very well, please do.
That's all that I'm saying. You're right.
To your lordship's query, do I have a problem in your lordship's recording that I have consented to what fell from your lordship? The answer is no.
Please.
If it happened in court, I will stand by it.
Very
I am
good.
not
That's
somebody
all
who will reside by
My
what
lords,
happened. in
may
court.
I be more positive? Your
That
lordships
is all
may
that I'm
record.
saying.
Mr. Sajjan, Nandkumar and Raghavan, if this is the attitude before mediator,
That's what I'm submitting.
I don't think you will be able to resolve.
But my lord,
We'll
may
withdraw
I
the
have my
government
lord,
order.
sir, your lordships are well aware, my lord, your lordships experience. A lot of this will be court histrionics.
Correct. I quite agree. I entirely agree.
At least
I entirely agree.
let there be consensus.
Seriously.
My
Let
lords,
there
please,
be consensus while passing the order.
Please
But all
record.
that I'm saying is, if they are agreeable to mediation, please record it. If they're
Please
not
do.
agreeable to mediation, don't record it. That's all.
My lords,
I
please
want
do
to be
record.
clear in my mind as to whether they're agreeable or
It's
not.
in interest of both parties.
I,
It's being
my
said.
lord, I understand what you're saying.
Both of you should go out as winners at the end of the day.
I
Very
would
good.
Ask your respective clients
from
not to stand on egos.
speaking personally, my lord, settlement is the best course.
We'll differently word your order.
No, that is your lordship's prerogative and talent. my lord. That
I
is
never
your
thought I would see the day that your lordship would have to virtually reserve the order for passing to mediation.
Put an end to the.
That is one thing
In
lord,
course
that
of
we
the
lawyers
hearing of
cannot
the-
do.
In course of the hearing of the appeal, when it was put to the councils, learned counsel, senior counsels for the parties, as to whether, having regard to the nature of the dispute involved, the parties would like to opt for undergoing the mediation process to resolve the disputes, while learned advocate Mr.
Nandakumar.
for the senior advocate Nand Kumar for the appellant.
Yes.
Stated that the appellant is willing to,
Please, on instructions, I'm stating, your lordship.
stated on instructions that the appellant is willing to go for mediation. Also, on the other end, learned advocate, senior advocate Raghavan for this one too, wanted time to seek instructions in that regard. Full stop. In order to enable learned senior advocate for the respondent to take instructions, stand over to 4th of February.
Please,
5th of February.
please, as your lordships.
Full stop. 5th of February. Full stop. Since one of the parties is to seek instructions on the aforesaid count, the court, kindly listen. The court considers it in the fitness of things that the parties, in particular respondent 2, shall abide by all the conditions of lease cum
Sale agreement.
sale agreement, including condition number 11 small b.
Yes.
Grateful.
We have said,
Great.
we have said.
Very good.
Yes,
Yeah,
ma'am.
Lord, and this, since it's your lordship's order, my lord, your lordship will record that this is without prejudice to our contention that they have no locus. I don't, because the orders of your own lordship, I would say, my lord, are being interpreted in a different way by party.
Till the next date.
Please, very grateful.
I'm very grateful, my lords.
Without prejudice to our rights. Without prejudice to our rights and contentions.
The above order is without prejudice to rights and contentions of both the sides.
Great, great,
Please, very grateful, my lords.
great.
My lords, may I utter one word? My lords, I owe my lord the Chief Justice an apology for uttering 1 or 2 words, my lords, which was possibly beyond my tangent. So my apologies.
No, sir, it is, everything is forgotten. It is, don't.
No, but I'm grateful. I'm generally, my lords, docile. Maybe
We
this
never
week,
remember the thing. Yeah.
grateful.
Always remember good things. Yes, next. Yeah.
Lord, I appear for the appellant in this matter, my lord. The appellant before your lordship, my lord, is CREDL, which is the nodal agency for renewable energy in the state of Karnataka. My lord, under the government order and the Karnataka electricity policy, my lord, whenever there is a change in the name of the generating company, my lord, that
Third learned senior counsel, so and so, notice returnable on
I take notice.
11th March, the impugned judgment and also limit.
No, my lord, the
See,
payment.
court-
No, the stay, my lord, the only question is, my lord, he is no way concerned. The power purchase agreement itself, lordship may hear me for 1 minute, my lord, I am at your lordship's disposal.
We'll hear you.
No, the power purchase agreement says, my lord, that the parties can create, the successor and interest are also included.
Maybe
It is
you
a
are
third
now
party.
change of the party, change of the.
No. No, Of name, my lord. Please, my lord.
In
Name is
2009,
changed.
when
name
there was
is
a
changed
change
and
in
Credit
name,
is no way
they paid
concerned.
the transfer fee. When it comes to 2021, they said, no, there is no power to impose a transfer fee, we will not pay it.
We are
In
not
2009,
admitting,
it
we are
was
not
paid.
admitting the appeal. We'll hear it little.
No, I will not take precipitative action.
Little earlier, 19th of February.
Deeply obliged.
And I may be directed to serve a copy, my lord. I take notice, my lord. Right away, I am taking
Learned
notice.
advocate, so and so accepts notice on behalf of some of this.
First,
So stay of the judgment, till the next date.
Deeply obliged.
There is a delay, Mr.
there is a delay, my lord. Therefore, I'll.
Sorry, I
count down
should have
the
pointed
delay.
that out. 17 days. My lords, what happened is, the only issue
What
was,
is there?
Sorry, my lord. I'll file objections to both lordship may hear it, my lord, in entirety.
No. Delay, who are the parties? Any to be
17 days, my lords. And the only issue was whether we file the appeal or the government files the appeal. That was the only discussion, my lord. And there was some time, unfortunately, that was
You
expended on
appear
that.
for whom?
One.
One, Techno Electric and Engineering Company Limited.
Yes.
So State of Karnataka, Mr. Harish will appear. Then Bangalore Electric Supply Company Limited, nobody. Then notice will have to go.
Very good.
That's what I was about to point out. Do you appear, Mr. Harish, for
No, I appear for respondent number 2, my lord.
2 on,
Number 3 notices to go, my lord.
3 and 4 both?
Please,
Very
3, 4 and 5 also.
All of this. So notice returnable on 28th of January.
Good.
Learned advocate, Mr. So-and-so and so-and-so accepts notice on behalf of respondent 1, whereas learned additional government advocate, Mr. Harish, accepts notice on this on behalf of respondent 2, State of Karnataka. Rest of the party shall be solved.
Well, let's let his undertaking be recorded, my lord, that he will not take any
No,
precipitative action.
there is no question, my lord. He is no way concerned.
That's
I'll
fine.
convince you.
So let's let them not file a contempt petition.
That will also come up before your lordship.
Will come here.
Very well.
That's what I.
Great.
This is number 12. Mr. Satish K.
Delay of 11 days.
Lord, the matter pertaining to Lord selection to the post of assistant professor in the Lord Department of Electronics. Lord, the short point for consideration is Lord as to whether Lord the age is to be calculated with reference to the last date for submitting the application.
But then notice 3rd February.
Lord, notice on both Lord.
In both.
There is a delay of Lord 11
days.
days.
If you have urgency in the matter, what should you do? That you should serve advance copy to the council. That they can appear in small delay, if it is small, can be condoned. But without condoning delay, we
Yes,
can't. That
can.
is the whole point.
This is number 13. MC Basuraj.
Published.
So 2016 order you are challenging in 2024.
In
8
fact,
years.
Malad, in the meanwhile, Malad,
Same.
he made number of representations, Malad.
16, 20 years.
And this is covered by the decision of Honorable Supreme Court, Malad, wherein, Malad, it has been held that recovery is impermissible. They have recovered the amount which was in its terminal benefits, Malad.
So what Rafiq Masi, what ground is applicable of Rafiq Masi?
Malad,
Retired,
retirement.
recovery from retired employee.
Yes, Malad. It is impermissible.
Notice returnable.
Please.
5th March.
This is number 14. Mr. Srinivas SV.
Lord, I appear for the appellant. The ground on which I am non-suited is primarily on delay and laches. I have only one submission in that regard. It was my case that possession of the land, I was always in lawful possession of the land. And if the acquiring authority is to show that they had taken possession in terms of the judgment in IDA, either a Panchanama or some Mahazar to show that possession is taken, then I am out. All that I am submitting before your lordships is, if the respondent authority can show that possession was lawfully taken, then I have no case. My respectful submission is that I have always been in possession. And to show that prima facie material, I place before the learned single judge 2 injunction orders at different points of time, my lord. One is in fact against the corporation, the Bangalore City Corporation.
Even then the notification is 1959.
Please, my lord. That
60 years.
Please, my lord. The difficulty was this, my lord. It is only in 2022 that the authority interferes with my possession, that I have pleaded specifically in the plaint. And from 22 to 24, why there was a delay, also I have explained it in my writ petition paras 12 to 18, my lord.
No, sorry.
May I just place,
Lord learned advocate Mr. So-and-so for the appellant.
may I just
and
place
the
one judgment? May I just place one judgment, my lord, on 300A?
And learned additional government advocate.
Correspondent number 1, madam.
Mr. Harish, correspondent 1. Challenge is directed against. Challenge in this appeal is directed against judgment and order. Judgment and order of learned single judge dismissing the writ petition by order. It has been an order dated 4th December 24, dismissing the writ petition. The challenge was thought to be raised by the petitioner in his original petition to declare the acquisition proceedings in respect of the land in question, which were undertaken pursuant to notification dated 3/6/59. Full stop. It is after paragraph gap of 6 decades that the petition was filed challenging the declaration and the notification of 1959. Full stop. 6 decades is too long a time to permit a litigant to assert his claim on whatever ground. Full stop. It is indeed a part of public policy that litigation after 60 years, length of, after yawning gap of 60 years, should not be entertained. Full stop. An attempt was made by learned advocate for the appellant that he has been in possession, to contend that he is in possession. Full stop. The court is afraid that whether this aspect even could be gone into after 60 years. The judgment and order of learned single judge could be said to be eminently just, proper and legal. No interference called for when learned single judge has taken a view that after 60 years of gap, the petitioners are not entitled to brief, the same is required to be upheld. The appeal is dismissed.
Cell number 15, ready notice matter, review petition by state.
My lord, it's a review petition filed by the state government, my lord. The order is at page number 27, my lord. In paragraph 4, my lord, there is a direction issued to the government to issue the form number C, my lord, license for stone crushers. The review is sought on the ground, my lord, that the Pollution Control Board has now issued a closure notice, my lord, to the unit, basically. And they have dismantled most of the equipment from the premises. Now there is no consent from the Pollution Control Board to operate the unit. Therefore, my lord, we are seeking for review that the writ of Mandamus that has been issued, my lord, for issuance of the license for stone crusher, my lord, is required to be modified, my lord. The procedure, my lord, is initially we issue a certificate of compliance. Based on that, they would apply to the Pollution Control Board and obtain the permission from the Pollution Control Board. Thereafter, the license in form number C is issued by the department. In this case, my lord, the certificate of for operation was issued, my lord. Initially, certificate of compliance, was issued, my lord, and they obtained the permission from the Pollution Control Board. Thereafter, the Pollution Control Board has now issued a closure notice, which I have produced along with the affidavit, my lord. In view of the closure notice from the Pollution Control Board, my lord, we are not in a position to issue any certificate, my lord. The reasons for closure, my lord, one more issue is there are school premises which is located within the permissible 500 meters is the distance, my lord. Restriction is there within the 500 meters. The license cannot be granted under Form C in view of section 6(1), my lord, of the Stone Crushers Act, my lord. So therefore, the joint survey report has been placed along with an affidavit. There is a road passing by, my lord, and the Moraji Desai residential school is located within the premises. There is a residential quarters, my lord, that has been allotted and constructions have come up. There are people living there. So therefore, for this particular unit, my lord, there is difficulty for issuing the license in the present situation, my lord.
Lord,
Where is the closure notice?
I have produced along with an affidavit, my lord, that was filed on 29th August 2023, my lord. The closure notice is at page number 17, exhibit annexure P3, my lord. An affidavit was filed, my lord, after conducting a joint survey.
that is dated 14th March 2019, Lord. Lord, the writ petition order was passed on 25th April 2019. After the closure order, after closure order, not the complaints were made. Not the learned government advocate made submission before the Honorable Court on the date of passing order.
Page number 17, my lord, is
Into
the order.
consideration of his
14th March
submission.
14th March.
14th March 19 is the order from the Pollution Control Board for closure, my lord. Page number 18 may kindly be seen, my lord. Various violations have been recorded. The order is at page number 18, my lord.
That is a subsequent development.
No, my lord, the order was passed in April, my lord.
Shortly
25th
thereafter, my lord,
April.
Pollution Control Board was not a party, my lord. This fact regarding the closure was not brought to the notice of this honorable court by either of the parties, my lord. That's the fact of the matter.
Lords, manner in which the present affidavit is filed, as if this honorable court has directed them to conduct spot inspection and issue notice and all that. But fact that, my lord, no order as such is passed in, my lord, directing the authorities to conduct spot inspection at all. On 9/6/2023, my lord, they took time to produce certain documents. That's all. But on the other hand, having taken time, my lord, they conducted this spot inspection and issued this notice, all that in the absence of the order of this honorable court. But no order is such.
Even
Yes,
if we reject your review,
Please.
then pollution control board taken.
There is no license from the
Pollution control board has already issued closure notice.
closure notice have been issued.
Pursuant to that notice, the board can take action.
Very, my lord, but now in the present situation, my lord, a joint survey has been conducted. It would be in violation of section 6(1), my lord, because
That's
now
for
the
pollution control board to look into.
Lords, absolutely right. Not the
Board is party here.
board is not a party, my lord, and neither of the parties brought it to the notice of the court about the closure that has taken place, my lord. Even the petitioner, my lord, who had received the notice, closure notice, he had not intimated the court and we were not aware about the fact of the matter, my lord.
Complete the board.
Very well, my lord, I'll do that, my lord. My lord, the
Some-
only limited request is that, my lord, if it was a writ of Mandamus to consider
You
the.
may be right, at the same time, you are arguing a new point.
I'll not do that.
It is not permissible. Review,
We'll implement the pollution.
leave to implement the Karnataka State Pollution Control Board as part of its respondent. First of learn and additional government adequate will take necessary steps to amend the course title.
and the Lord.
After the course title is amended, the registry shall issue notice to the newly added party, that's the pollution control board, returnable on say 12th February.
Correct. Lord, I'm sorry that instead of not stretching the matter, not Lordship expressed, Lord, the board, the pollution board has to take decision on the point of that issuing the CFO and all that. CFO means that the consent for operation. But on the date of passing order, all complaints were there. Based on his submission, Lord, government advocate submission, this order came to be passed. Not subsequently, all this.
He is saying that on the date of the passing of the order by learned single judge.
No, this before this court, my lord. By the division.
Before this, so kindly take paragraph
The
3
division
of the
of
order.
this court, my lord.
This
By this
order
Paragraph
is
3 of the order.
April 19 and this closure is March 19.
March, not this, after the closure order, Lord, I made compliances. That is there with the Lord board. Now, Lord, this order was passed.
Be knowing, the knowledge has to be
Yeah.
attributed to you about this closure when the petition was disposed of. You did not disclose it.
Sorry, Lord, on the date of passing order, Lord, I was not served this closure order. Lord, after that, I came to know I complied with all the compliances. Now, Lord, this affidavit is filed, bringing to the notice of the subsequent developments. This development, Lord, this development, Lord, which they produced before the Supreme Court without the order of this honorable court. But in the in their affidavit, they say that pursuant to direction of this honorable court, we conducted spot inspection, we have issued notice, and this is the development and all that they are producing.
We are not allowing the review. Let the
Sorry.
body will know this. It will give the entire picture of the
Very well.
court once the body is there. We will also facilitate the court how to dispose of the matter.
My lord, if it was for a mandamus to consider the request, my lord, then we would have taken this into consideration. There's a positive direction to issue the certificate.
So there is a lacuna on your part also.
Yes, my lord. No, we should have also, we were
correct
not
it.
aware of that fact, my lord,
You
otherwise.
can't
we would have-
correct in a review process. So these are the things to be gone.
I'll amend the last statement. This, number 16, to Somsekhar.
Lord, after series of litigations, Lord, the government passed an order annexure N to take back 3 acre 18 guntas, Lord, and give it to the public. That order is not implemented till today, Lord. Annexure N is the order passed by the government. Translated copy, Lord, your lordship get at page 159, Lord. The operative portion of the order, Lord, 169.
Today it is whose possession?
But this is, the land was given to the fourth respondent Ballot for construction of sports complex. Instead of that matter, it was used for construction commercial complex. Ballot, there were several litigations.
First
Ballot.
complex or children's playground?
Ballot, that's what it's not for children playground. Now, the government directed that to take back the land from the fourth respondent and use it for children playground. Ballot. That order of the government, Ballot, which is passed on 29/9/2022 is not implemented at the instance of the fourth respondent. Ballot. They are not taken the position and made use for general public.
You are supposed to file.
My lord, it's a BBMP.
No, state government order.
Order BBMP is not implementing, sir.
Yes, that's correct.
We are BBMP.
Yes, my lords. We'll seek instructions in this, my lords.
When will take instruction? This is in November 24th, this was. 3 months have passed. Learned council, so and so, he wants to take instructions, stand over to 19th of February.
Please.
17 is urgent. Number 18. Number 18, the Nikhil Vital party in person.
My lord, in this I have received the report. My lord, it is in a sealed cover. My lord, with my lord's permission, if I could hand it over.
Today this temple is under water. What's that?
My lord, it's in the backwaters of the Hidkal Dam. It is in the backwaters of Hidkal Dam.
Right now it is under the water.
Yes,
There is water.
it is in the dam.
Right now, no, right now the temple is underwater.
Yes, it is under water.
No, no, right now, as on today, is it underwater?
It's
It will be accessible in,
submerged, the temple is submerged.
in March, it will be accessible.
That is what the report says.
Yes,
That because of the water.
yes, it's submerged in the water.
Submerged in the
because-
water, it's not possible to visit it at this time. Now there will be no water.
It may be deferred until March, until the water recedes.
Last year, it was surveyed by archaeology. So,
My lord, they are seeking for relocation of these two temples. I'm sure there's going to be a law and order problem, my lord. Relocation of this temple from the dam.
So, no,
My lord, there are so many people who come and visit this temple. They have the superstition that when it is submerged, they have one form of superstition. The moment, my lord, the water recedes, they come, they perform the pujas in those two temples. They are seeking for relocation of these. So we'll have to look at it from the point of view of the district administration also.
Now, the state authorities will have to say it, whether the general public over there are very particular that the temple remains there only, or whether they want it to be shifted. It should be as per the wishes of the
My
people.
lord, the petitioner is seeking for it, not the state government.
No, it's not the question of state government, madam. It's
Your lordship, if we don't relocate this temple, then it will collapse. So,
so
the question is, what do the public want? What is your survey? You can't.
My lord, that is the report which we have got.
That does not say anything about it. It says that for us to go and make necessary inspection, the water has to recede. We appreciate that.
Then
can-
we'll seek further instructions.
Lord,
with the-
You are required to verify and state what the public in that area want. The devotees want.
Yeah.
I mean, the opinion of other community members may not be relevant. But the opinion of
Lord, one-
that particular community, that becomes.
Lord,
relevant.
one other principal issue, if I may submit, from what the writ petitioner is contending, is that if it is not, it's a matter of conservation. The law requires the state government also to conserve an ancient monument. His contention is that in the writ petition, if you do not conserve, it will be gone forever. So to that extent, it will be an obligation of the state government to conserve it. And when they constructed the dam, they should have ensured that whichever area falls in the backwater, they should have, when they relocate people, they should have relocated the temple as well. So therefore, there is an obligation of the state government to do it.
pursuant to this court being moved by the petitioner in this public interest petition, public interest petition, by passing order dated 11/11/24, the court required a committee to be constituted, which was to be constituted by the Chief Secretary of the Karnataka, to visit the Allama Prabhu Swami temple, for its structures and remains, to find out, report to the court as to whether they are to be treated or they could be treated as ancient monuments and antiquities for the purpose of applying the provisions of the Karnataka Archaeological Sites Act 1961 for the purpose of their preservation. Also, today when the petition came up for consideration, very well learned medicine government advocate Srimati Nilokar Akbar presented before the court a sealed cover containing the report of the committee. Also, the sealed cover was permitted to be opened. Presence of learned party person as well as learned in presence of petitioner, party in person, as well as in presence of learned additional Solicitor General of India, Mr. Kamath, for the Respondent, Union of India. The report of the committee dated 13/12/24 indicated that presently the temple and its structures, etc., tends submerged in the water of the dam and what dam water,
Backwaters of the
Backwater.
Hitkal Dam.
backwater of the dam, and that until the water recedes, the inspection could not be effectively carried out. It is stated that the entire process has to be carried out only when the competitive authorities confirm to certify that the said process will not alter or affect the, or will not affect or damage the dam and the water resources. Full stop. In course of the submission paragraph, it was submitted that the water normally recedes in the month of April and
April.
full stop. In this view, the committee is directed to pay a visit to the site again to carry out the directions in order dated 11/11/24 and to submit a press report as required by the court. Full stop. Put upon. Then vacation, after vacation. After vacation.
Lord, the copies of the report may be made available to us also. I mean, there is no secret about it.
I don't have a copy. It's a sealed, in a sealed cover.
When we are reopened.
Or maybe, Lord, we'll apply to the registry. Registry may be directed to make the copies available.
July 7th July. Copy of the report will be made available by the registry to the councils for the party.
I'm grateful.
Well, not even to
To all
me.
the councils of the party, including the petitioner party.
Very good. Grateful.
Lord, even I don't have a copy, Malon.
You are also part of the councils of the.
Obliged, Malon.
In fact, you should, will say that copy of the petition shall be made available by the office to learned additional government advocate Srimati Illofer Akbar, who shall in turn provide the copy.
Yes, I will. Obliged.
council.
I will do that.
Lord, I have a request not connected with this case, more on the administrative side. There is a display board here which shows the status of the cases. It's a very old model, very too small. In all other court halls, there are bigger LCD panels. Lord,
It is here.
it's too small. It's a very old model, maybe at least 15 years old.
We'll change it. Sure.
I'm grateful. I'm grateful.
Yes.
Number 19, Suresh TS.
Your Lordship, this is a matter that's arising out of the stopping of quarrying work, Your Lordship. Your Lordship's judgment, which is at page 147, that's not been followed. Your Lordship had given strict instructions that they would have to hear us, share the documents that they're relying on, and then pass orders. Your Lordship, they claim now that it is coming under reserve forest, which is not under the reserve forest. Their very own orders state that it is not, Your Lordship. And this order is passed by the mining as opposed to the forest department. So they do not have the technical know-how as to whether this comes within that area or not. Page 147 is Your Lordship's order, which they have again refused to follow.
Lordship, also we are covered by this Honorable Court's judgment with respect to stopping of work. Technically, they're not entitled to do so. And if your Lordship is also directed that we might be able to continue work until such time that they actually pass a relevant order.
My lord, let not incorrect submissions be made, my lord.
It is remanded.
Yes, my lord may see who has passed the notice. My lord, that is dated 20th March 2024, page 138. It is passed by the senior geologist.
Correct. Senior geologist, your Lordship.
And he has
Ultimately,
not been
the
made a
order at
party in
page,
these proceedings.
your Lordship, page
And my lord
148
may
is
take,
such order.
may I be permitted to submit? My lord, and my lord may take the directions which my lord have given at page 148, paragraph 7. This is the notice 138, page 138 is the notice issued by the senior geologist. And my lord's order may be seen at paragraph 7. May I read, my lord? My lord, as a result, the notice dated 20th March 2024 is set aside. The subject matter is remanded to the senior geologist, Department of Mines and Geology, Mysore, respondent number 1 herein, to decide the case afresh. Respondent number 1, the senior geologist, shall take the decision after supplying all the documents to the petitioner which are sought to be relied on by him in support of the stoppage notice, and further directing the authority to extend to the petitioner the opportunity of personal hearing by intimating the petitioner about the date in this regard. While the request of the learned advocate for the petitioner for permitting the petitioner to allow the quarrying application could not be granted, since the competent authority is yet to take appropriate decision, it is provided that the entire exercise as above shall be completed by respondent number 1 within 2 weeks from the date of receipt of copy of this present order, without insisting for certified copy, which may be produced by the petitioner before respondent number 1 subsequently. Now my lord may see the reason that is being assigned. My lord, that my lord gets it, the ground. My lord, non-compliance with this Honorable Court's remand order dated 15/11/2024 in full and absence of involvement of relevant authorities, that is respondent number 2, 3, and 4 throughout the decision-making process, and especially at the stage of personal hearing. My lord has directed the senior geologist to supply the copies of the documents which, my lord, the petitioners themselves had. And now they are saying that, my lord, these authorities were not present and that we have violated my lord's directions. In fact, in the notice for stoppage, we had referred to the letter issued by the my lord, Deputy Conservator of Forest. My lord, the petitioner should have been my lord, alert enough, my lord, to request for such a presence to be made.
Your Lordship.
Your Lordship, this is an order that was passed stating that ultimately your Lordship's order has been extracted. No reasoning is there. Your Lordship, in fact, the translated portion is at page 59 and 60. The impugned order, your Lordship may kindly see, page 59 and 60. Absolutely no reasoning, extraction of this Honorable Court's order, and ultimately passing the very same order. Your Lordship, when the
They are
Forest
not
Department...
diligent and they
I
put
did
the
not
blame on
interrupt.
us.
Kindly give the same courtesy. Your Lordship, the Forest Department has 12 years ago held specifically that we come 10 kilometers away from the forest area. All of a sudden now, they say stop work. Your Lordship, either my lease has not been cancelled, I have continued to do so, and I'm covered by your Lordship's judgment. Can I ask the council to hand over this judgment? Your Lordship, it is issue of stopping of work, whether they're entitled to again stop work, your Lordship, with absolutely no basis. Your Lordship, might we hand over the judgment of this honorable court, which is on the very same aspect? Your Lordship, at paragraph 5, Your Lordship, when Lordship had remanded the order, had clearly stated at page 149 of Your Lordship's order that the nature of the land has to be decided. Your Lordship, they are not willing to do that. They are not following Your Lordship's directions at all. At page 149 at paragraph 5, Your Lordship has said the nature of the land has to be decided. Your Lordship, when they have already held that it is over 10 kilometers away, if they're going to change their mind overnight, then they would have to pass a detailed order as to how that nature of land had suddenly changed. Your Lordship, all of a sudden asking us to stop work. And now, Your Lordship, for the last 1 year, we have paid huge amounts. And even last year, they increased our capacity. We have all the clearances. And in fact, even at serial number 6 earlier, Your Lordship had in a slightly different matter, wherein when there are all clearances there, asking for stoppage of work is not permissible. And here's a case where every single department has cleared us. Last year, they in fact extended our capacity and increased it. We have paid an additional amount. We have the mining license for another 15 years, Your Lordship. And all of a sudden, they say stop work without any reasons. Paragraph 149, page 149, paragraph 5, Your Lordship.
Government, the letters of revenue authorities, your own document, annexure A, it says it is government land.
Huh?
It says it is government land.
Please.
A,
Where does it say?
revenue authorities. Just come to page number 38 and 39. What Tahsildar has written and what your revenue officers. Revenue officer says it is government land. The forest officer says it's a forest land. Now there is a conflict between your revenue department and forest department. Now, which has to prevail? How you have come to the conclusion that it is a forest land? You will have to explain that.
My lord, that is the reason why we had requested, my lord, at the time when my lords had passed the order in November 2024, my lord, they should have been diligent enough, my lord, to make a request to this honorable court.
See,
No.
it's your documents at the end of the day.
My
They need not produce any documents. They
But
can't
they-
produce any
my lord,
documents.
they have produced those documents. They have explained those documents in the order annexure A.
Show it. What is the contention of your revenue authorities? Show it. Your own revenue document, what do they say that?
My lord, that is, my lord, revenue documents, now I have to seek instructions with regard to that. My lord, but the contention saying that we have disobeyed the orders of this honorable court is incorrect. My lord, the notice that had been issued, my lord, by the Deputy Conservator of Forest, my lord, which is stated by, my lord, the senior geologist in the conclusion portion of the order, my lord, that should have been challenged, my lord. My lord will get it at page 61.
That is secondary. You first clarify to the court whether it's a forest land or not, based upon your own officers' letters and communication. What does your revenue department say? What does your forest department says?
My
See,
lord,
Forest Department,
in so many
154, you know.
cases, you are hanging private individuals because of a rift between your own forest department and your own revenue department. This is not an isolated case. Be sure by your document what is the nature of the land.
my lord, that.
You will have to explain to the court.
My lord, may I make one submission? My lord, the grievance of the petitioner is, we have not complied with the orders of my lords, which is not correct. Secondary, what my lord has
If that
posed,
was the case, I would
my
have filed a contempt, your lordship. It is a
my lord,
combination of
the
not
secondary
following your
question
lordship's
is,
order.
my lord,
and-
this I will seek instructions. But with regard to
You-
the first prayer, my lord, it doesn't survive at all. My lord
Absolutely
has
not. Your
said
lordship may kindly see
the
page
senior,
54. It
the
is very
senior
clear. A
geologist matter
detailed
should be
order has been
remanded
passed.
back to the senior geologist. Senior geologist has, my lord, noted the documents that were produced and he has passed this order. Now, with regard to the question posed by my lord, I'll have to seek instructions.
Your lordship, might I just kindly hand over this judgment, which is exactly on the same issue of stoppage of work. Your lordship may kindly see this. Stoppage
My
of
lord, they
work
have
is
no
itself
vested right, my
impermissible
lord,
for
to
them to
insist
prevent.
and say, you
Yeah.
give it only to us, you give it only to us and pass orders in this particular fashion. No. My lord may grant me some time.
Your
Prima
lordship,
facie,
this,
my lord, we
your
have not
lordship,
violated the
constantly
orders
they
of
say
my
give us
lords.
time, your lordship, the urgency. There is a surface hanging as against this petitioner because he's been unable to even pay his employees. We have stopped work. And your lordship, this constantly shuttling between different agencies, your lordship may kindly see page 54. They have themselves given a very clear order. And only after that we got our NOC, your lordship. Page 154, your lordship may kindly see.
Were they granted license to quarry?
My lord, they had been granted.
They have been granted for 20
Lord,
years.
may I seek instructions in this matter, my lord?
Yes, my lord. It's valid for 33
My
years.
dear,
2033, it goes up to, my lord.
up to 2033, your lordship. And all the amounts have paid. And last year they gave us an extension.
Have you
Last-
produced that license? Where is the license produced?
It's produced.
Copy of the-
Aparna, the page number.
P, your lordships. Annexure P 184, your lordships. With effect from 21/1/2013 for 20 years.
License is valid for a
Please,
period
your
of 20 years?
Yes, your
Please.
lordships. They've never
Respondent,
disputed it.
government. License is valid for a period of
Lord,
20 years.
my lord, My lord may grant me a week's time. I'll have a consultation with the learned advocate general and if necessary, bring him because there are similar matters like this and I don't want to be put in an embarrassing situation.
My lords, in answer to your
Your
question.
lordship, they could take
valid.
all the time they need if we get some interim protection, your lordship, because we have not even been able to pay
The
any
senior
of our laborers.
geologist against whom the order is
Yes.
sought to be quashed has
Yeah.
not been made a party. My lord may have this on the 27th. I'm not asking for a long date. 27th.
May I just seek interim relief that till such time we are at least able to pay our laborers, your lordship, that is all. Let them seek whatever instructions, your lordship. In fact, they were directed even during vacation to have their objections, your lordship. Yet they have not filed their objections. There are no instructions. This is the third round of litigation that they've been making the petitioner run pillar to post, your lordship. Might I only seek some interim protection, your lordship?
My lord, there is no violation of my lord's orders. Remand order, whatever my lord had directed, yes, that has been complied with, but now a fresh query is posed before my
Para
lord.
5 has
I'd
not been
like to
complied
have
with.
an interaction with the learned advocate general and make a submission.
20th.
28, oblige me.
Obliged, your lordship.
Number 20.
20,
My lord, similar matter, my lord.
28 too.
Same petitioner, my lord.
Same,
Serial
my
number 20, it's the same petitioner, but pertains to a different quarrying.
Same.
Number 21, Sheikh Mali Patil.
Sir, I'm appealing as a proxy for counsel for respond number 1 and 2 minutes. My lord, counsel for respond 1 and 2 is out of station, my lord, for an emergency. Kindly have it tomorrow, my lord. Counsel on record for respond number 1 and 2 is out of station, my lord, on an emergency.
Where is the order? This final order?
Lord, this
My lords,
appeal against-
your
this is an
lordship
appeal against
had
an interim
already
order.
noted by your lordship's interim order
This is an
that
appeal
even though
against-
this is an interim order, all the contentions that, all the prayers that we had sought before the learned single judge have been answered by this order. Subsequently, Manoj, learned single judge has disposed of the petitions in terms of the very same order.
Lord, the file,
In terms of the very same order, petitions are disposed.
the main mod.
So this is the main Manoj's order.
The order has merged in the final order. Therefore, an appeal has to be appropriately filed if they aggrieved by them.
Manoj, an application is filed, Manoj, for amending the petition to include the final order, but this is the main order. Where, Manoj, it is your lordship's interim order at paragraph 2, interim order dated 5/12, takes note of this very same Manoj's contention. While it is true that the order brought under appellate jurisdiction is an interim order and in normal circumstances, the court would not entertain the appeal against the order, which is an interim in nature. However, the present order finally denies the students from appearing in the examination, holding that they are not entitled to have the fifth attempt. In that view, the order would said to have the trappings of finality in respect of the rights of the students to appear in the examinations.
Merged order will warrant a separate appeal. It cannot be as of the
It
date
would,
of
it
that
would only
file.
be a formality, Maloj, if I have to again file an entire appeal, Maloj,
Let
in another
judicial
order.
procedure be followed appropriately. Once it merges, a proper appeal has to be filed and you can do it tomorrow itself, but it has to be in a proper manner. It can't be an old matter, old filing, and then say that this becomes that. We will have much to say about that itself. But that is once the appeal
On
comes
time.
on board.
Tomorrow.
Tomorrow itself.
Tomorrow. All let to.
Great.
Number 22. Ashok Krupalini, party in person.
My lordship, this is for the early hearing for that today, but since it has become infectious because today it has come for the early hearing. So kindly give me the date 23rd of this month. I have postponed my flight also. 23rd of this month.
This will be infectious.
Pardon?
This has become infectious.
Today, if it is not, because if it is for early hearing, so since the early hearing application is coming today,
It's IA is right. IA number?
I, one of 25.
Go ahead, man. So what is to be done? He wants time.
If it can be heard today, I am ready. I am ready to argue.
For you to.
But if that 23rd date may be given, 23rd of this month,
Learned party person wants this matter to be listed on 23,
23,
accordingly,
top of the board if possible.
to be listed on 20.
I'm on R2, my lord. My presence may be recorded. I'm for R2.
You already recorded in
And
this board.
there is another application, IA2 of 25, for taking some documents and the judgments on the record. IA2 of 25.
You want time, we'll give. No other miscellaneous things.
So
Without knowing the subject matter, yes.
23 is urgent. So number 24,
Thank you.
the complaints in contempt matters.
Connected to my lord serial number 10 that my lords heard earlier today, this is connected, my lords, to serial number 10, which my lords heard earlier today, my lords. This also be posted the 5th of February, my lords.
Lord, what has happened, Lord, after my Lord, order of my Lord, this court, my Lord, you complied with the order. Lord, that order was challenged before my Lord, the learned single judge. Learned single judge dismissed that, my Lord, the case, my Lord.
And the writ
This
appeal was
contempt
there
is
today,
nothing
which
to
has
do.
been adjourned. This also
Let
may
him-
be adjourned to the 5th.
Let him
my
proceed
lords.
with the writ appeal, my Lord. This,
Please,
my Lord,
that's what I'm asking
this,
for.
my Lord, contempt, my Lord, does not survive. We have complaints.
That my lords had earlier also
Read petition is filed.
Writ
writ
petition
appeal,
dismissed,
my
my
lords.
Lord.
My lords, Mr. Puvai and Ms. Nandkumar were appearing in that writ petition,
Lord,
writ appeal, my lords, serial number 10
Lord,
today.
we have filed, my Lord, complaints report on, my
It
Lord,
may
26/9. That was challenged before, my Lord, the learned single judge. Learned single judge dismissed that. Against that, my Lord, writ appeal is pending. Let him, my Lord, proceed with the writ appeal. I have no objection. But, my Lord, this is, my Lord, nothing, it does not survive. In view of, my Lord, complaints, my Lord, report filed by us, my Lord.
We'll dispose it of.
Please, my Lord.
Parties-
Maybe it may be adjourned to the 5th of February along with the writ appeals,
not
my
serve
lord.
purpose.
I'll make my submissions, my lord, I'm led by learned senior counsel, my lord, in that matter. We have certain submissions to make on that compliance affidavit, why it's not proper compliance. I'm only asking for time on the
Lord,
5th. If
Lord-
on the 5th, my lord, the writ appeals are pushed
Lord,
forward, I will not push, I will
Lord-
not ask for time in the contempt, my lord.
Learned single
On the
judge, my
5th,
Lord,
it will-
holding that,
sir,
my Lord,
one
the
second,
petitioner,
wait,
my Lord, doesn't have, my
Don't
Lord,
interrupt.
locus standi. My Lord, they have dismissed, my Lord, the writ petition. Now, my Lord, against that, my Lord, writ appeal is pending. My Lord, it has been, my Lord,
Once I have some
accepted.
submissions to make on the compliance affidavit, I'm saying it's not full compliance. I'm led by learned senior. It may post on the 5th. On the 5th, my lords, if the writ appeals are pushed forward,
Lord,
I will not take them. I'll close it on the
Not
5th.
at all, my Lord.
I'm just asking for time on the 5th. So the learned senior who is leading me may make the submissions, my lords. That's all I'm asking.
On last occasion, also, my Lord, same submission was made, my Lord. We have filed complaints with, my Lord, affidavit, my Lord, on 26/9.
Exactly what I'm saying, that the compliance affidavit is not compliance. That is the
Lord, I have
submission I
produced, my
made.
Lord, the order copy of, my Lord, the passed in, my Lord, WP number
Serial
2585.
number 10, my lords. I'm the complainant and the appellant are one and the same, my lords.
Does not survive, my Lord.
Judgment and order brought under this contempt petition.
My lords, if my lords is passing an order, my lords may seek for a passover. If I can bring my learned senior counsel to lead me in the matter.
Is already subject matter of writ appeal number 1772 of 24 and 1797 of 2024. Those appeals were posted on board today at seal number 10 and 10.1, which have stood adjourned to 5th of February.
5th, my lords, please.
As per the order passed today. Full stop. In view that the order alleged to be said to have been violated is is under challenge in the writ appeal. No purpose will be served.
Lords may seek.
In keeping this contempt petition pending. Full stop. However, it is directed that the parties shall abide by the outcome of the appeal.
Oh, bless.
Grateful. Contempt petition is disposed at this stage.
Number 25,
Vali Patil PS.
This is regarding the issue of e-Khata in favor of the petitioner.
What is the?
Your Lord, I have
Lords,
published all necessary documents. They say that I have not produced.
Respondent number 2 is the competent authority, my lords. Although the state government has filed, it has to be exercised by the respondent number 2. They have also filed an affidavit, my lords.
I have. Respond number 2, is a Panchayat Development Officer.
Yes. Khata is to issued by the Panchayat Development Officer.
One minute. Just 1 minute.
The affidavit has been filed by the,
He has not filed a compliance affidavit saying that I have not filed the documents. In fact, I have filed my counter affidavit saying that all necessary documents relating to my property that to show that I am the holder of the. In fact, I am holding a old Khata. Now, the government has introduced a policy for issue of e-Khata. They have no difficulty for issue of e-Khata in respect of existing Khata property. But I am not asking the fresh Khata,
lords, PDO is represented by a council, my lords, Panchayat Development Officer. Notice was issued to the PDO last time.
But this Khata is to given by whom you?
No, my lords, Panchayat Development Officer. Competent authority is the Panchayat Development
Let
Officer.
him.
Compliance affidavit has been filed, my lords, due to inadvertence. This subject.
Mr. J. Naveen.
You have served him?
Mr. J.
He's the
Naveen.
Deputy Commissioner.
Well, Deputy Commissioner is the officer, my lords, but it comes from, the Khata is issued by the PDO, my lords, Panchayat Development Officer.
Not a party.
My lords, we are formal parties, my
the
lords, pro forma.
respondent.
Notice has to go to the PDO, my lords, respondent number 2.
Not gone so far.
I think is represented by one JN Naveen, my lords.
And let
Mr.
us
Naveen is appearing for they have filed a compliance affidavit.
inform him. 2:30. 2:30 or some other date.
Next year, tomorrow, I will have to search him,
We'll keep it on February, 11th February. Please inform. We'll be assembling after 10:15.
Still number 26,
26 and
Swami
27.
MBA.
Milots, we have
26 and
filed as
27 will be called on
compliance.
31st. Maybe called on 31st.
31st, 30.
26.
27,
Same.
28 is adjourned. Still number 29, Mr. Ranganath S. Jois.
So in this matter,
29.
we have filed writ appeal, Milots.
My lord, this they are stating ever since, my lord, this is a person who is a senior citizen who has rendered 30 years of service and he has not been regularized. On 2 occasions, he approached the court and finally this honorable court has directed that he shall be regularized, my lord, holding that he is eligible. This order is passed on 14 September 2023. Now we are in 2025, my lord.
Milots,
Still
writ
they are-
appeal has been filed, Milots. Your lordship have passed in similar matters where writ appeal has been filed, that unless we obtain an order, we comply, similar order may be passed, Milots.
complied subject to result of the appeal, if at all they want to intend to file any other. Order has to be complied. The driver, retired driver, having rendered 30 years of service.
Learned additional, let him, learned additional government advocate, Srimati Pramod Nikishan stated that writ appeal has been, that the appeal is filed against the judgment and order of law in a single judge, which is made subject matter of contempt in this petition. In that view, the writ appeal shall be listed along with the present writ appeal of 24.
FR number is there.
FR number, office objection, it has been coming, they have not complied. It has been filed long back, they have not complied with the office objection, that they are showing the appeal and then
Milots, Milots, next date of hearing
That
will
view,
come.
the writ appeal number 7.
FR number is there, Milots.
Writ appeal FR number 7 shall be
1880.
listed on 10th February, along with the present contempt, shall be listed for hearing, and along with which the present contempt petition shall also be listed. Full stop. If the office objections are not complied with in the writ appeal, the state shall comply with the office objection on or before 5th of February, failing which the appeal shall stand automatically dismissed without reference to or order of law.
Pledge.
Still number 30, Chandrakant are moving for accused number 2, your lordship. So complaint.
So far as respondent number 1,
Has
we have,
reinstated.
he has been reinstated by the government.
My lords, but they have not continued any monetary benefits, my
Writ
lord.
appeal
They
is-
only partly complied. And writ
filed
appeal was
order
before
of
the
learned
honorable
single
court today for non-compliance of office
Writ appeal is
objection.
filed against the order of learned single judge. WA number 57 of 2024.
When it was filed?
It was filed on 6 June 2024.
6 June. So before compliance of or after compliance?
Before compliance.
Before reinstatement?
I have no instruction. I will.
We'll find out that.
Lots,
I'll
partly it's
find-
been complied, my lord, so.
No, if it is partly complied with before filing of writ appeal, we'll require you to comply with total.
I will
Subject
find, I will
for-
find out. Kindly have it next week.
You must have date. All right,
Next week, Mikhail.
next week.
And
Yes, but let them,
SN but name, my senior name may kindly be deleted
Pardon?
because he is no more.
Who?
My senior is. Our name may kindly be,
So what do you want?
our name may kindly be,
So, well, the file वगैरह तो नहीं file.
yeah, we have a call.
Governor educated so and so state that he is file वगैरह on behalf of this phone number. We on whose behalf?
SN but on behalf of accused number 2.
This phone number 2. The official show the name of learned advocate. This one so and so as appearing for this one 2 while notifying the petition on the next date, which shall be 11th February.
Much of. Number 31,
That's-
Tarish NR.
That's in this matter also, we have filed our compliance, my lords. This is with respect to recovery proceedings to be initiated by the deputy commissioner. My lords, the person against whom the recovery proceedings has to be initiated.
Appear for
My lords,
petitioner.
we have issued notice and we have drawn proceedings that company is not in existence. We have issued paper publication. My
matter.
lords, I am producing the memo to that extent. We have made search and we are not able to identify the properties, my lords, but
Serial number 31.
31. 31.
next matter, I'm sorry.
And appear for petitioner in this case, my lord. The previous date of hearing on 24/9/2024, this honorable court was pleased to my lord observe
My lord,
on
this is
24/9/2024.
dismissal for non-prosecution, my lord. We are filed the recalling application, my lord.
My lord, civil court decreed the suit, my lord. My lord, thereafter, my lord, suit, appeal was filed. My lord, appeals, considering the, my lord, continuous
Appeal filed.
absent, my lord, appeal came to be dismissed. Thereafter, my lord, I submitted representation. My lord, after representation, my lord, Mandamus, my lord, was issued against the respondent. My lord, in the writ of Mandamus, my lord, they appeared. Even there, my lord, there is no steps are taken, my lord, into either to recall the order, my lord. 1984, my lord, I have protected the, my lord, site. Till today, my lord, I am not in a position to enjoy the land. He is a retired school teacher, 82 years old man, my lord. Kindly see, my lord, I have produced, my lord, Annexer A, page number 13.
Who will be- This is for consideration of representation.
My lord, kindly see the page number 49, my lord. This is for the dismissal for non-prosecution. We have filed the recalling application also, my lord.
My lord,
Appeal.
Appeal. We have filed the appeal, my lord.
my lord, no steps are taken, my lord, till after, my lord, 5 months, my lord, 1 year
46.
is over, my lord. One year is over. And
Kindly see the
considering
order.
this, my lord, this honorable court on 24/9/2024 was pleased to observe, my lord. Kindly see order sheet dated 24.
Only for decree. What is the decree?
Well, order dated 24/9/2024, kindly seen, my lord. This honorable court was pleased to observe on 24/9/2024 in the order sheet, my lord. My lord,
It is there.
even in spite of that, my lord, they have not taken any steps, my lord. My lord, this kind of, my lord, they are, my lord, harassing the petitioner.
My lord, 6/8/24, we filed the recalling application before the division bench of this honorable court, my lord. We also filed the memo for posting, my lord.
My lord,
It's not yet posted, my lord.
When you have
We
filed?
will
When did you file?
kindly have it next week, my lord. Kindly have it next week, my lord, we will.
Will? By next week, what will you do? What will you tell us? You grant time, but by the next week, what will you do?
After the appeal, we will comply it, my lord. After posting the appeal, we will comply it, my lord.
That is right, but within 1 week, what will you do? So appeal is dismissed for want of prosecution. Your appeal. Appeal is dismissed for want. of
Non-prosecution.
Yes, my lord.
In the appeal also, my lord,
And-
same thing, my lord, they have not turned to the court. Considering the continuous absent, my lord, this honorable court, my lord, was pleased to, my lord, dismiss the appeal for non-prosecution. My lord, same, my lord, sorry to submit, same attitude is, my lord, the petitioner is suffered from the, my lord. 1984, he purchased the site in Ocean. Till today is not in a position to enjoy the. My lord, in the writ of Mandam,
When it was stated on the last occasion that order which is subject matter of contempt petition, is also subject matter of regular first appeal number 1307 of 16. The court observed as under in its order dated 24/9/24. Yes, court, it is hereby provided. Left, yellow. Today when the contempt proceedings paragraph after quoting When the contempt proceedings came up for consideration, learned advocate Ms. So the respondent stated that the regular first appeal has been dismissed for want of prosecution and that the necessary steps will be taken for revival of the same, for restoration of the same, and for seeking appropriate orders there. Full stop. Accepting this submission, it is directed that necessary steps which the respondents may want to take shall be taken within period of 3 weeks from today, including obtaining appropriate orders in the regular first appeal on merits, from failing which the respondent shall be exposed to the aggravated contempt. Full stop. Stand over to. February 19th. Whatever you want to do it there.
Yes.
Otherwise, we'll take a view seriously.
It's number 32. Maitri Krishna.
Lords, this is with respect to the recovery proceedings to be initiated by the Deputy Commissioner. Lords, we have taken all steps, my lords. This company which was existent then, now it is no more in existence. When we went to the place to issue the notice that in that place that office is not there, then we have returned to the registrar of companies also to see whether any properties or any office of the company is there. And we also have taken a paper publication, my lords, to see whether there are any properties advertising to the public to come up with any properties or the address of the defaulter, my lords. But we are not able to identify any properties. We have put in a lot of efforts in this recovery proceedings, my lords. If they can give us any properties or any leads, if the complainants can, then we will do the recovery proceedings and complete it and give it to them, my lords.
My lords may see the compliance affidavit that they have filed. In that, this compliance affidavit, it has already been filed, my lord. It's on record on 3rd
This is a
September.
paper publication in furtherance of the compliance affidavit.
On 3rd September, my lords, they filed a compliance affidavit.
3rd September.
Please, my lord. On 3rd September, they filed a compliance affidavit. If my lords would see para 3 of that affidavit, where they say that they have written to the Registrar of Cooperative Societies. The memo that they have filed now, my lord, is in respect, they say that they have done a paper publication, but they have in fact written to the Registrar of Cooperative Societies as per their compliance affidavit.
Yes, both we have
Please,
done.
my lord, but there is nothing insofar as a response received by them. If my lords would see for a moment their compliance affidavit, they say that they have written to the Registrar of Cooperative Societies seeking for the for details in respect of the company of the society, my lords. But what has happened subsequent to that, whether they have even followed up on their letter, because they don't say there is any response.
Lords, if they
Lord,
can
paragraph
identify
3.
any properties, then we will initiate
Let me just see
recovery
paragraph 3
proceedings.
of their compliance affidavit. my lord.
This was existent very, very long back, somewhere in 90s, my lords. Now we are not able to trace the properties or the office of the defaulter.
At least, my lord, if the Registrar of Cooperative Societies provides those details, what they have sought for, or if they are even followed up with them, what they say, my lord, in their compliance affidavit.
They have followed up.
No, my lords, they say in paragraph 3 of their compliance affidavit, my lord would just see for a moment. They say that they have issued notice to the registrar. They have issued a letter to the Registrar of Cooperative Societies dated 21st August 2024. It's at page number 3 of their compliance affidavits.
August. Yes.
They say that they have written to the Registrar of Cooperative Societies to furnish the details regarding the assets of the society or any related organization in order to proceed with the recovery proceeds. The copy of the letter dated 21st August 2024 is produced and marked as Annexure R4. After that, my lord, in respect of the information from the Registrar of Cooperative Societies, there is nothing.
We have not
the memo that
received
has
so
been,
far, my lords.
my lord, at least they should write to them and get that information. The memo that they have filed now is in respect of what they say is a paper publication that they have taken out in one newspaper. But the information, my lord, should be with the cooperative societies registrar. And they have written to them on 21st August. And after that, they have not,
they say they have received no response, but they have not even written to them once to find out any details from them. In fact, my lord, this is the point that I had submitted before my lords on the last occasion, and they had said that they will look into that. I'll also verify, my lord, whether there is any other assets, but at least they should receive this, they should get this information from the Registrar of Cooperative Societies.
I will postpone for 3 weeks.
Please.
We'll postpone for 3 weeks. Like. You are seeking to recover from whom?
I'm sorry, my lords.
You are seeking to recover the amount from whom?
From one management of.
From the management of Hotel Cooperative, from the management of Hotel Cooperative Societies Limited.
We never received notice in the main petition. We dispense with the notice. My brother is very rightly, pointedly pointing.
Please, my lord, it was.
Now alleging contempt against them.
I'm not against them, my lord. I'm not in contempt against them, because the direction was issued insofar as respondent number 1 to 3 is concerned. Because the only reason I had come to this honorable court in my writ petition was seeking that they had failed to recover the amounts. Because they had the duty lies on the deputy commissioner to recover the amount as per land revenue. My lord, if I may just
We close the country.
Lord, may I make
Unnecessary arrest the officers of the state.
My lord, it is their duty to, it is the
Your duty to ensure that number 4 is aware about the proceedings. Number 4, management is never aware about any proceedings. Now
No.
you are alleging contempt through the state government.
No, my lord, may I just submit this? What had happened was this. The labor court, my lord, passed an award against the management of Hotel Cooperative Society, in which they were very much present. They did not challenge that award. That award, since it was not implemented, and the amount of what the labor court said that an amount of compensation must be paid to the petitioner. Since that amount was not paid to the petitioner, then, my lord, I had approached the authorities for recovery of the amount. The authority for recovery of the amount, my lord, is to be done under the Land Revenue Act. The deputy commissioner was required to ensure the payment of to recover that amount. Since that was not done, I had approached this honorable court, my lord. It is not that they were not served before the labor court. Before the labor court, they were very well aware of the award. So they.
The compliance affidavit.
My lord, may I just make one submission? I'm sorry for interrupting, my lords. My lords may just see my prayer in my writ petition, which is there in the, which has been noted at page 10 of my, at page 10 of the petition filed by me.
It is not available with us.
I'm sorry, my lords.
The petition is not available.
Not the petition, my lord, on the order, please, at page 10. My lord, the prayer is extracted, my lord. That's the reason I'm just pointing it. This writ petition is filed under Article 226 and 227 of the Constitution, praying to direct the nature of Mandamus directing the R1 to recover the compensation awarded to the petitioner of rupees 3 lakhs only, along with terminal benefits and interest as per the award of Principal Labour Code dated 17th November 2018. Therefore, my lords, my only prayer before the Honorable Court was seeking a direction
to the respondent number 1 to recover that amount. And it is in that light that respondent number 4, the notice was dispensed with. It's not that I'm seeking for anything, there was no fresh cause of action in that sense, my lord. The only thing that I was seeking for. Because, my lord, the adjudication in respect of what was due to the petitioner had already been made. It had already been made before the labor court. That award was not challenged. My lord, my respectful submission would be only this, my lord. There is an award that is passed in respect of the petitioner.
The present contempt petition comes up for consideration in the following background as well as subsequent developments. Full stop. Petitioner was dismissed paragraph from service by respondent number 4. Management in the proceedings of the labor court. It was directed that the petitioner shall be reinstated with full back wages and continuity service. On a single judge in a petition filed by the present petitioner directed state of Karnataka, directed the state to recover the compensation awarded to the petitioner with terminal benefits. In which petition respondent 4 was party. However, the petitioner prayed for dispensation of service to the said respondent number 4, and the court granted. It is to be noted that respondent 4 was a necessary party to be served in relation to the subject matter dispute. Full stop. The contempt petition was filed paragraph against the judgment and order of learned single judge dated 3rd April 24, wherein the state was directed to recover the compensation, the complaints affidavit came to be filed by the state to submit that despite best of the efforts, it was not possible to trace the existence of respondent 4, nor the address of respondent 4 was available despite search in that regard. Paragraph. Respondent 4 shall be added party in the present proceedings, and notice shall go to the said newly added party, which was already a party in the writ petition, but had no opportunity of appearing. Full stop. Learned advocate for the petitioner shall pose necessary amendment in the post title of these proceedings. Full stop. After the amendment is carried out, registry shall receive notice to the newly added party, returnable on 12th March.
Great.
Those paper publications may be taken on record. We filed a memo today. We have also taken paper publications memos to trace the identity and their assets.
What is filed today?
Lord's memo has been filed today.
Dated 27/11/24, along with the accompaniments filed by learned additional government advocate today shall remain on record.
Yes.
Number 33, R. Kiran.
I appear for the respondent bank, my lord. This order of this honorable court has been complied with, and I also filed the order of this honorable court has already been complied with, and I filed the affidavit also, my lord.
My lord, they have paid the principal amount, my lord. However, they have not paid interest, my lord, on delayed pension, my lord.
Along with the interest only we have paid, my lord.
There is no provision for interest. है इसमें order में है?
Yes, my lord.
कहाँ? Where is the order regarding payment of interest?
My lord, though there is no specific order in the writ petition for payment of interest, my lord, the RBI circular is clear about payment of 8% interest on the delayed pension, my lord.
My lord, this is the government, he is not the employee of the bank, my lord, he is a government servant, and whatever the advice issued from the advocate,
Learned
Attorney General's
advocate
office, that has been paid, my lord.
So fairly concedes.
Permitted to produce the RBI circular, my lord. RBI circular, my lord, on delayed pension, there's 8%.
Learned advocate so and so fairly submitted that the principal amount, that the amount of pension was already paid. In that view, she could not dispute that there is a compliance of the directions of learned single judge. However, she submitted that interest on belated payment of pension is not paid. She relied on the circular of the Reserve Bank of India dated April 24, 13th April 2012, paragraph. When the directions of learned single judge are seen, there is no direction regarding payment of interest. In that view, court is not able to carry further the submission of learned advocate to petitioner in this contempt jurisdiction. The contempt proceedings are required to be closed according to closed full stop. As far as the claim for interest is concerned, it will be open for the petitioner to make a representation to the competent authority in light of the circular of the Reserve Bank mentioned as above, or in the alternative, institute independent legal proceedings for recovery of interest in accordance with the contempt petition is disposed of accordingly.
December 34. Vijay
And for the complainant, my lord, this is second round of complaint.
Affidavit for affidavit one, my lord. Reply by affidavit.
Last
Please
time
for
also they
time,
took
my
time
lord.
time.
1 week.
Pardon?
Reply by affidavit, my lord. 1 week time, my lord.
Why?
Last time also they took time, my lords, because the complainant retired on 31/12/2017, my lords. Till now, they have not paid even provisional pension, my lord.
Now this contempt, earlier also contempt was.
There was a contempt, my lord. They
My lord, 1
assured
week.
that it would be complied.
My lord, 1 week time, my lord.
Earlier, learned advocate Ms. B.L. Sanjeev for Bangalore Nagar Palika stated that the direction will be complied within 2 weeks. This order was passed on April 24.
Yes, ma'am.
Contempt was disposed of. So then what shall we do?
My lord.
Commissioner to remain personally present.
Yes.
Commissioner shall remain personally present.
Okay.
Yes, learned advocate Mr. So and so for the Bengal Nagar Palika stated that the commissioner of the Nagar Palika shall personally remain present. Correct?
My lord.
Mr.
My lord, my senior, no introduction.
We don't know. Bring your senior. Where is your senior? 2:30. Come at 2:30.
Okay.
Please.
Number 35. Yes.
Lords, I am filing my compliance affidavit, sir.
But you convey to your senior that we are passing this order. Or either you don't bring your senior, bring the commissioner himself. That will also do. Choice is yours. Since how long you are practicing?
6 months, my lord. 2023 enrolled 6
Pardon?
months practice.
Little longer.
6 month practice, my lord.
6 months, then pardon. So you want to 2:30 or tomorrow? 2:30.
Lord, it's an appointment of compassionate.
Filing the compliance affidavit.
Please, my lord, I make my submission after.
Hmm?
I raise 1 week time, my lord. Lord, this is the case for compassionate appointment, my lord. That the application is rejected only on the ground that she is a daughter, my lord.
What you have done?
Lords, this is with respect to compassionate appointment, my lords. The Honorable Supreme Court has held that the date on which the death has
Go
been.
ahead. We are interested in what the state has held.
My lords, we have rejected, my lords, following the Supreme Court decision.
My lord, is my lord, 2021 itself, my lord, act itself is amendment, my lord. 2021, my lord, they have issued an endorsement stating that married daughter is not entitled, my lord. Since, my lord, even Supreme Court says, my lord, at the time of consideration of application, my lord, the act should be,
Yes.
yesterday itself, there is a notification, my lord, by the government, my lord, at the consideration of the application itself, the rule is to be followed, my lord.
We've in fact produced the Honorable Supreme Court's decision, my lords, which clearly states that the date of the death of the employee should be considered. So this is prospective, my lords. The date of death is 2017 and our amended rules came into force only in 2021. They have filed the application also in 2017. So then what was holding the field, that notification rules were followed. The Supreme Court is very clear on that aspect, my lords. In fact, produce the very judgment, my lords, at page 38, it is very clear, my lords.
My lord, week time
Therefore,
may be
my lords
granted, my
may
lord. I'll
kindly,
look into it and make my submission. Now they have given reply, my lord. I make my submissions, my lord. Since, my lord, the date of consideration of application
this
to be
judgment is-
considered, my lord.
yes,
Because since she is only the daughter,
yes,
my
we-
lord.
we may. That reconciles all conflict.
My lord, date on which the application is considered, the law is in force, my lord. The law is in force. Daughter is entitled, and she is only the one daughter, my lord, to their parent. There is no son, only one daughter, my
We
lord.
can't decide in this contempt jurisdiction.
Because since, my lord, this order endorsement issued by this, saying this order, my lord, our single judge has been quashed, my lord. After lapse of 1 year, my lord, they have not considered it, my lord. After filing the contempt petition, they have issued this, my lord. 2023 itself, my lord, order has been passed, my lord. Even then, my lord, they were not challenged this order, my lord.
my lords may kindly,
A single judge in order dated 21st September, the direction of a single judge in his order dated 21st September 2023, while disposing of the writ petition, was to direct the reconsideration of the case of the petitioner for giving her a compassionate appointment, notwithstanding that the petitioner was a married daughter. Full stop. The decision was required to be taken by the authority concerned within stipulated time. Full stop. When the contempt petition was filed, the respondent has now that consideration you are bringing about the date of application and date of death and date of consideration is irrelevant. Because look at the direction. Look at the direction. We have to confine in that corner on, or you challenge this order in appeal. If you are of the view that learner single is not right, but what is provided is that your consideration should be in light of the judgment cited supra. So one
Please,
of the
and in
judgment is of the-
accordance-
one of the judgment is of this High Court, Srimati Bhubaneswari, which holds that the married daughter cannot be discriminated. And probably there is an amendment in the rule also.
yes,
Rule is
may
already
I
amended.
submit on that, my lords? It says consider and ultimately it says consider in accordance with law. The lords may kindly take page 38, what the Honorable Supreme Court says. So when we go in accordance with law, we are bound by this order, my lords. My lord, 13/1/2025. 38 may be kindly be seen. Notification was issued, my lord, at the date of consideration of the application, my lord. This rule is already amended, my lord. This has to be considered, my lord. I'll produce the notification itself, Lordship my may lord. kindly see 31, above paragraph 2021, 25, my lord, the order has been passed by the government, my lord. Lords may kindly see three lines, my lords, what this Honorable Supreme Court has said above paragraph 20. Therefore, we are of the considered view that the interpretation as to the applicability of modified scheme should be dependent on only upon determinate and fixed criteria such as date of death and not an intermediate and variable factor. Now, this, my lords, is very applicable here because the date of death is in 2017, and in compassionate appointment they have to make an application within 1 year. So they have made an application in 2018. As on that day, what was the law prevalent, my lords? We have made it applicable. We have brought an amendment only in 2021, and that is prospective, my lords. This is what the consideration and the endorsement has been issued, my lords.
So at the time of deciding, the new rules have come.
Deciding, but the application, my lords, was made in 2017. And 2018, 17 was the death, 18 was the application. My lord, in Bhuvaneshwari's case, my lord, the My civil lords, judge has relied upon. my lords, in that, kindly, my lord, date of 2000 death, my lords, date of death is. 2016 is,
Bring all judgments will consider.
please, my lord, please.
There is something in his.
Obliged, my lord, sir.
So come on 5th of February.
Please, my lord. Much
All
obliged.
judgment.
Obliged.
Yes, Bhuvaneshwari and the subsequent change
Sir,
in the rules.
please, my lord, 13/1/25 notification is passed by the government, my lord, saying
13/1/25.
13/1/25, my lord. To be considered.
25.
25 minutes. 25, my lord, 25. What was we have considered
not-
as on that day, what
Oh,
was
my
holding
lord,
the thing?
in furtherance with this order, my lord, furtherance with this order, my lord, or notification has been passed.
Bills. 10
Please, madam.
5th of
The passover matter, cell number 34, Mr. Vijaya Simha Reddy, ED.
For the complaint. Lord, I'm extremely sorry, my lord, I was not there. My lord, in this matter, my lord, he has made an application before the appellate authority. That would be considered in a week's time, my lord. We will make whatever the payment is to be made, we will pay it, my lord. In a week's time, it will be paid.
Stand out to 5th February.
Grateful. I'm sorry, my lord, I was not present.
So 230 matters, cell number 63, Mr. Girish Kumar R.
Lords, this matter
63.
has been complied, my lords. The student has been allotted the seat and she's also completed her studies, my lords. Lordship may kindly take the memo of compliance filed on 25th September
Here is
2020.
your learned friend.
Mr. Girish Kumar R.
Is party in person? Party?
My lords.
No.
No, my lords. No.
Learned additional government advocate Srimati Pramodini files memo dated 24/6/24. To submit that. To submit in the affidavit in, submit in the accompanying affidavit of compliance that the order dated 19/1/24 passed by Learned Single Judge is complied with. Post is paid.
My lords.
Post is paid.
Cost, my lords, is with respect to KEA, my lords, Karnataka Examination Authority. We are,
Insofar as the part of, insofar as the part of the direction regarding admitting the student,
please,
learned advocate for the petitioner is not present in that view, to be listed on 22nd January at 2:30. Who is R2?
my lords.
Who is R2?
KEA, my
who
lords.
will pay-
KEA, my lords, Karnataka Examination Authority.
KEA will pay the cost.
Please, my lords, the direction is to KEF to pay the cost. Appears that they have filed a SLP, my lords.
So in this notice is notice. We'll say notice written.
Obliged.
On 29th of January, learned additional government advocates, communication, accepts notice and submits that the part of the compliance with which the state is concerned is complied with inasmuch as the student is admitted.
Please.
In the order of paragraph, learned single judge, there is also a direction to pay the cost imposed on the Karnataka Examination Authority. Full stop. It is expected that before the next date of hearing, the said part shall also be complied with by the Karnataka examiner.
Number 64. Chair will add up.
Matter, my lord, an RP was filed. RP has been disposed now, my lord. They will take action, my lord. The lordship may give us 2 weeks' time, my lord.
At the request of Learned Reverend B.L. Sanjeev, stand over to 17th February. Obliged.
So number 65. For the accused.
My lord, in this matter, on 9th, I had sought for time for testing, and this honorable court had given time till the 15th of January, and we have not been able to complete the testing. I request for an extension, my lords.
My lord, the testing began on 15th. We had sent multiple emails. My lord, there are one important aspect in this case is on the 2nd of January, when the commissioner started his work, certain videos were transferred, which was supposed to be the reference point to see if there is any tampering or functionality of the website. These were given by the complainant herself. Starting date is on May 2021, ending on July 2023. Those videos have not been shared with us. They say it is confidential. If there is no reference point to us, it becomes very difficult for us to ascertain whether they're talking about functionality or they're talking about
Report
tampering.
was to be submitted by.
He is not submitted, my lord. Last date of hearing, I had asked him, but then he said that I'm harassing him, I'm badgering him. All these things, so I kept quiet. The commissioner made these submissions, statements in the recording, so I kept quiet afterwards.
Submit a report to this court.
He's not done it.
Why?
I don't know, my lord.
My lord, because testing is, I asked,
Will implement the commission. Who is the commissioner?
Sridhar Parthasarathi.
my lord, on the
Commissioners-
last date, this
What have you
honorable
included?
court has,
You can't prolong like whatever you say and we prolong, go on prolonging this contempt jurisdiction. It has to come to an end. We'll hold up the you are obnobbing with the commissioner.
no, my
Why
lord.
he is also not responding to the court direction?
My lord,
Who is that? Advocate is there or?
No, my lord.
no, my lord, he is a technical
Whosoever he
person.
may be.
My lords have already ordered last date to implead him as a party.
No, by order dated 9/1/15, comma. By order dated 9/1/25. Once Mr. Sridhar Parthasarathi, who was already appointed a commissioner by the court below, was directed to facilitate the testing of the website in the presence of the plaintiff as well as respondent, and to submit report to this court. When the present contempt proceedings paragraph come up for consideration today, there is no compliance about the direction to submit the report regarding functional testing of the website paragraph. While on one hand, learned advocate Ms. So-and-so seeks time that the functional test, that the period for functional test may be extended, the court takes a serious view that the commissioner has not responded to the court's direction. Therefore, commissioner said Mr. So-and-so Sridhar Parthasarathi shall be impleaded as party respondent. Is already impleaded or not?
He is,
He will
my lord.
implead him.
He is.
Not impleaded.
He is impleaded, my lord. On the last date, he is impleaded. This
Yes.
honorable court by,
Take court serious view of the matter. The said commissioner who was already arrayed as party respondent is directed to remain present on the next date. Full stop. The time to on the functional testing and submit report is extended up to 11th February. Full stop. If the report is not submitted, if the report is submitted, the commissioner's presence will be exempted.
my lord, testing, we shall proceed with the testing and complete it by the 11th, my lord.
One submission, my
If
lord.
the direction to complete the functional test and submit a report is not complied with by the commissioner or the parties, a serious view will be taken that the contempt is committed in the contempt proceeding itself.
My lord, one submission. The videos that have been shared on 2nd of Jan.
Don't know, these are not the judicially
Yes, my lord, but-
manageable things.
Yes,
It is
my
your technical thing.
But they are claiming it to be confidential.
Everything can't be judicially.
Yes, my lord, I
managed.
understand. But commission has to cooperate with
There is
us.
a
my lord.
limit to the intervention of the court in the matters of disputes.
Yes, my lord.
Such or like that, such as this testing and etc. Yes, next.
Is number 66, Mr. Adi Narayanappa.
We have
Till-
complied,
till number 60,
we have complied the order.
Draft the,
complied with.
since they have complied the court direction, may kindly draft the.
Learned additional government advocate. Ms. Pramodani, stated that the directions brought under the contempt of court act are complied with. Full stop, learned advocate, Mr. So and so confirms the statement. In that way, the contempt proceeding does not survive. It is dismissed, they are dismissed as contempt petition is not, does not survive, it is dismissed as not surviving.
Number 67,
Here
Vinod
also
Kumar
we
K.
have complied, my lord, sir.
to Vinod Kumar K.
Complied with,
Complied, my lords. RTC is
What-
produced.
what are the direction?
My lords, the directions were to update the revenue records having regard to the acquisition of the title by the petitioners in terms of the registered sale deed dated 29/9/2023. Lords, we have filed our compliance affidavit on 22nd August. And accordingly, we have updated, my lords, the revenue records are also produced, page 4 and
Where is the order? Of learn a single judge.
single judges,
Page. Yes.
my lords. Page 11, my lords. Page 13 is the operative portion, paragraph 4.
Yes. Following was the direction in order dated 22nd April 24 of learn a single judge, extracted from paragraph 4, of fourth paragraph 4. It is in respect of the above directions that non-compliance was alleged and the contempt petition was filed. His contempt petition was filed. Today paragraph, learned additional government advocate states that the directions are complied with and the revenue record is updated in light of and in accordance with the sale deed concern. Post of the affidavit of compliance figures on record of the proceedings. Paragraph. Since, however, learned advocate of petitioner is the updating of the revenue record is also communicated to the paragraph. However, since learned advocate for the petitioner is not present, in order to give him a chance to confirm the compliance, stand over to 22nd of January to be listed at 2:30.
So it's number 68, the Kamadoli Manjula Devi.
Here also, lords, RA has been heard and the order has been passed and we have filed the order, my lords, in the compliance affidavit. It is at page 18 of the affidavit, my lords, the translated copy.
Some orders are also passed.
Please, my lords, we have enclosed the order. The direction was to pass the fresh orders in accordance with law.
Learned advocate of the petitioner is not present, stand over to 4th of February.
This is number 69, Mr. Girish TR.
This matter applied for the complainant's counsel. The last date, a counter affidavit was filed. That's reporting so-called compliance with the learned single judge's order. I would respectfully submit, there is absolutely no compliance. In fact, this is a classic case of trying to divert attention from what the learned single judge had directed. I just submit this, my lords. What had happened before the learned single judge was this, my lord, that we had filed an application seeking podi and durasti of a property in respect to which my name was entered in the mutation records way back in 2005.
That's page 35 is the operative portion of the order.
Yes. So what is page 37 order? Okay.
There was a contempt filed earlier, my lords, where the government submitted that they were not able to trace the file. So therefore, we ourselves voluntarily submitted that we will help the government reconstruct the file before the missing file reconstruction committee. Now, what the committee does, my lords, is goes back 20 years in time and says that please cancel the entry. In fact, the application was to conduct podi durasti. I have already crossed all those hurdles. In fact, there was an order of the deputy commissioner which set aside the recommendation to cancel the entry back in 2011, based on which I filed an application. In fact, a writ petition. 2019, the assistant commissioner once again says, please conduct podi durasti. Now, my lords, essentially what the missing file reconstruction committee has done is set aside the deputy commissioner's order without having any reference to it, which was dated 2011, and said, please cancel the mutation entries. So therefore, the clock is set back 20 years. In 2005, my name was entered in the mutation records. So my only suggestion is this, if the government could reconsider in light of this, if they feel that the documents I voluntarily submitted that I will submit all the documents available with me to the missing file reconstruction committee. But now I can't be worse off for having volunteered my own help.
They have reconstructed the.
Yes, my lords, your lordship may kindly see the proceedings drawn by the missing committee headed by the deputy commissioner. The discrepancies or the non-availability of the documents are produced at page 13 of the affidavit. These are the observations, my lords, very clearly where in the page 13 of the compliance affidavit, my lords. These are the discrepancies mentioned from 1 to 9, my lords.
Discrepancies in their record and your record.
My lords, it is the committee after verification. These are the proceedings, my lords, and that based on this, they have come to conclusion that podi and durasti cannot be done.
No,
it was referred to missing committee, my lords.
If
missing
that was
committee,
the conclusion, I really would not. Then I possibly was I would have to challenge that. But kindly see the recommendation right at the end. The meeting has been concluded. My lords, has page 14, last paragraph. The meeting has been concluded. The direction to the Tahsildar Mysore Taluk to submit a proposal to cancel the entries. If they said podi can't be done, I'll challenge it for whatever reason, but not to cancel my entries. That goes beyond the mandate.
these are only the proceedings, my lords. No, the order is passed at annexure R1.
No.
Government, if you look at the single judge's order, it is to conduct podi and durasti. If you come to page number 35, consider the application which would be filed by the petitioner and do the necessary podi and durasti work. Either you say you are going to do the podi and durasti work, or you say you are not going to do the podi and durasti work. By this particular endorsement, you cannot confer or whatever, you cannot say about the rights of the parties concerned. You cannot rule about the rights of the parties concerned. Because this proceedings before, what is it? District Committee for Rebuilding of Missing Records of Land Grant. They don't have any powers either to confer the rights or not to confer the rights.
Please, my lords.
Okay. So, pursuant to this particular order, can podi and durasti be conducted or not? That's all you are required to say.
Lords,
Due to lack of these documents, we are not in a position to conduct the podi and durasti. Your contention is by grant you got the property.
That's right.
You are the original grantee.
Or grantee's son.
You are
My
the
father
grantee's
was-
son.
That's right.
So if he is the grantee's son, then as per the law, you are supposed to conduct the podi and durasti, then only put them in possession of the property. But anyway, you have not been doing it.
Lords, may I make a submission? The order passed by the Honorable Court is to virtually to consider their application for podi and durasti. Lords, podi and durasti is done. Lords, first we build the records. If the records are intact, then the subsequent step is to do the podi and durasti. When the records are not available, we refer it to the missing committee. Now, this missing committee, my lords, has in detail, it is headed by the Deputy Commissioner and there are 3 other members, Assistant Commissioner, Tahsildar. Now, when they secure all the records, they go into the records. When the required number of record documents are not available, then podi and durasti cannot be done.
See, that committee can be formed internally to look into certain aspects. But it does not have the legal sanctity either under the Karnataka Land Revenue Act or the Land Reforms Act, wherein it can rule about the right of the person.
Please,
Now, podi and durasti has to be done by ADLR and the Tahsildar, the
Please.
jurisdictional ADLR and the Tahsildar. Now, you can submit this report to ADLR and Tahsildar, and they in turn can give an endorsement stating that they won't be conducting podi durasti. They will be at liberty to challenge it.
Very well.
But see, this is
I
not.
understand.
That's it.
Challenge.
Once they haven't issued, and also what has happened is there is
Endorsement, based on that, we'll have to issue.
just to give a background, but back in 2006, the Tahsildar had made an identical recommendation to cancel the revenue entry. I challenged that before the Deputy Commissioner. Deputy Commissioner said that he rejected the proposal, said that please continue and please carry out the podi durasti. So from 2011, I've been pursuing this matter, and now I'm back in 2005 with the same recommendation. That is another aspect the government may have to consider. I've produced those, because 2011, I specifically raised this contention that you cannot cancel my revenue entries. And if my lords were to see my contempt petition, at page 25, I've produced the DC's order, which says, he says, I reject the proposal to cancel the revenue entry. And then the Assistant Commissioner once again writes to the Tahsildar saying, please conduct the podi durasti.
Because that is my respectful submission would be beyond the contempt jurisdiction. Lords, pursuant to this, we will comply the orders. That's,
Misdirected yourself. This in passing, in producing this minutes, because that is no answer to the compliance.
obliged, my lords. We'll file compliance minutes.
What compliance?
Lords, based on the missing committee, Tahsildar would be the competent authority to issue.
Correct. Advise properly and
Please.
so that they know whether you are complying or not.
Obliged, within a week's time.
30th January.
Obliged.
Great.
Number 70.
Lots appearing
B.
for
Rangaram.
accused lots. Lots in this, it is a matter of issuance of e-Khata lots. We have received the application and we have considered it on 17th of December 2024 lots. And since it is all from the online process, it takes 45 days to complete the process lots. From the date of receipt of the application to complete the 45 days, it will complete on 28th January 2025, this month lots. So as soon as the date has been completed, immediately we'll issue the e-Khata lots. Kindly it may be listed after 28th January.
May I
lots.
submit with
Even
lots of kind
after-
permission. I filed the application in the year 2019. Father has died in the year 2018. I filed the application in the year 2019. I filed the writ petition before this Honorable Court 2024. This Honorable Court on 5/8/2024 passed an order within 2 weeks it has to be done. Subsequently also I filed the application. Till today they have not done it, simply dodging the matter by one reason or other. Whereas in the case of the other, I already filed one set of document so that some person has purchased the property in the year 2023. Within span of 25 days, they have issued the e-Khata to that person who has purchased the property. Whereas my father is having the e-Khata earlier occasion also. I produced a copy of the e-Khata to the concerned authority. They have not done it.
Lots,
What is your difficulty in deciding?
it is since the change of Khata lots, we have uploaded, it
No.
will automatically get uploaded in the online
You
lots.
need to
After
decide.
that, we have to.
Kindly listen, you have to decide the representation only. What prevents you from deciding?
They have not done it in the
And
email.
next, we have considered the application and we have also received the application from complainant lots. Even we have the acknowledgement for the same lots.
Irrelevant.
But
Only
the
decision on representation is relevant as far as compliance. When you will do?
lots immediately after 20.
We'll do one thing. We'll do one thing. We'll ask this Commissioner Chamaraj Nagar to come with the decision personally,
Yes, lots.
Ask
Day
him to
after
be present.
tomorrow.
Ask him to be present.
day after tomorrow.
No, lots. This he has some meetings. Even I called him today.
Let him
lots.
come.
Yes, lots.
Learned counsel for the, you are for number 4?
I'm for appeals. Respondent number 4.
4. Learned is one 4 states.
No.
Commissioner.
Same, municipal.
Commissioner.
Same.
You will ask the commissioner to remain present personally before the court. On which date?
Lots, it may be taken up after 28th, lots.
After?
28th January.
So on 29 January,
Yes, lots, please.
learned advocate Miss so and so states that this one or 4 commissioner shall remain personally present before the court, along with copy of the decision
Yes, lots.
taken by the representative.
Yes, please.
Full stop. The only direction, the write down, the correct order, write down the correct order. The only direction in the order of learned single judge is to decide the representation, which is to be decided by respondent 4, the commissioner, Chamaraj Nagar. Despite the observations made in previous order dated 7/1/25, when the petition comes up for consideration today, learned advocate Miss so and so for respondent 4 has raised his hand, her hand in helplessness stating that there is no decision forthcoming from the commissioner. Full stop. Taking note of this paragraph, the court directs the December 4 commissioner to personally remain present on
First week of February.
You said the 28th, now he is going to first week.
First week of
On-
February.
on 6th of February
Yes, Lord.
with copy of the decision taken on representation. If the decision is taken and produced through learned advocate for learned advocate, the personal presence of the commissioner shall stand dispensed with. So you understood the order or not?
Yes, Lord. So he has to present on the 6th of February with the compliance affidavit.
That is the only order. You read slowly when the copy of the order comes. See that it is decided and produced.
Obliged.
71 urgent, number 72. PV Malla Reddy.
Respond number 6. Video is not maintaining the road. It belongs to BD. Not maintaining the road. We are maintaining the road.
In this case, on the last date of hearing, my lord, they directed the BDM, my lord, to conduct a spot inspection and whether there is a hurdle in the roads, my lord. We have conducted filing the affidavit, my lord. We have conducted the spot inspection and there is no barricades, my lord, in the road is the free, my lord.
I appear for respond number 6.
The BBMP, which is has conducted, there's no barricades as on.
Correct.
So no barricades in passing the order.
There is no obstruction now, as of now, please, my lord. But it is only in respect of serial number 14 of the schedule of the properties, please, my lord.
What remains now? Everybody says no barricades, no barricades.
No,
You are
so
saying.
so far as road is concerned, please, my lord. I'm deeply obliged, please, my lord. So, in respect of other properties, please, my lord. So the prayers may kindly be perused, please, my lord. The prayers may kindly be.
Everybody says no
Ink
barricades.
page number 17, please, my lord.
Prayer.
Ink page number 17, please, my lord.
Demolishing illegal structures, compound wall by removing barricades. But there are no barricades.
Number 1, please. Prayer number 1, please, my lord.
What is it? Prayer number 1.
1.
All are similar.
Direct the respondents 1 to 3 to clear the public use the scheduled properties by demolishing the illegal structures, compound wall, by removing the barricades in the RCDP 80 feet road, public park areas, civic community sites to facilitate the public to use the said public park areas, public roads, civic community sites, etc. vested in the BDA for the use of the public, including the petitioners and consequential reliefs, please, my lord. Totally about 17 properties which have been released in favor of the BDA under the release deeds annexure A1 and A2 and A3, please, my lord. So it includes park areas also, please, my lord. Not only roads, park areas also. All these are compounded. 105 acres is compounded. They are not allowing any public to pass through these roads and use the public amenity. There is parks, please, my lord. That is my grievance, please, my lord.
All maintained by us.
And there is no dispute about the releasing of all these areas, nearly about 22 acres of the area, please, my lord, in favor of the BDA. It is under the registered relinquishment deeds, annexure A1, A2, A3, please, my lord. That is as per the condition laid down at the time of sanctioning of the plan, please, my lord. There is no dispute about whether these properties are BDA properties or not.
That should be given by the association under the.
4th and 5th respondents are private party.
My lord, it's a private parties. This is practically nothing, my lord. I'll tell you what the real truth is.
Relinquished what?
My lord, I am, my lord, representing the association of owners of the residential part of it. There are 10,000 people who reside in this complex. There are about 2,500 apartments, my lord, and 10,000 people live there. This road, my lord, ends in that property itself. As a matter, I'll tell you, lordship, this is, my lord, as a matter very serious because it affects the lives of those 10,000 people. Now, someone has come
who claim that they have properties beyond that. But the road doesn't end there. My lord, the other day, they came and demolished our wall.
Sorry, please.
Yes, it is true. Please, 1 second. They demolished our wall and we had to file a suit against them to restrain them from demolishing our wall. They come and demolish our walls. Then they say they want to enter inside the property. This is all apartment complexes. It is not, my lord, that there are free layouts available where people can come inside. Now, these petitioners seek to claim that they must be allowed to enter the building, go inside, utilize the properties which are inside.
Sorry.
That is exactly what they are saying, my lord. And this road, in my humble submission, my lord, actually it is a private street. It is no doubt, my lord, relinquished to the government, but not to the government, my lord, but to the BDA. But the BDA has not declared it as a public road. And this road, my lord, is not maintained by the BDA at all. The entire road is maintained by us even as of date. And my lord, today, certain private parties whose properties are beyond it seek to espouse a private cause in the public interest litigation before your lordships by filing this public interest litigation saying they are blocking our road and all of that. Continuous, my lord, interdiction by them.
From
BDA.
Yes.
See, when you approved the plan,
Yes.
were the builders or the developers of the property or the owners of the property required to relinquish
Yes, they
certain areas in favor of BDA?
Yes, ma'am, they are relinquished. I have produced
Okay.
the.
Number one is the road area.
Yes, ma'am.
Number two is civic
Park and civic.
park assets.
Yes.
So the road and the park, they become public property.
Yes, ma'am. I have produced.
Where private persons and wherein private persons, irrespective of where they reside, can access those
Yes.
areas.
Yes.
It is not limited to the persons residing in that particular locality, right?
Yes, madam. They have, as per them, they relinquished even the road is also, I have produced the relinquishment deed, my lord, the.
What is the relinquishment deed?
Along with the affidavit.
A1 and A2, A3, please, Milord.
I have produced today, my lord,
Annexure
along with
A1,
my
I
affidavit,
think page
document
number
number 1
25,
and.
please, Milord.
So the sanction plan required them to relinquish the property.
Yes, yes. It's 2006, my lord, the plan was sanctioned.
Totally 22 acres of land they have relinquished, please, Milord. Even though.
These are the areas that are relinquished on paper. This schedule is civic.
Beg your pardon, madam?
The red petition.
The red petition. As per this, reviewed by BDA, we have to put a petition for review. Schedule A property is a larger. Schedule B property are the specific properties. Schedule A is the larger property. Page number 14.
Yes, madam. It is the entire property.
Entire property.
Large.
Of Schedule A property, Schedule B property is relinquished in favor of BDA.
Yes, ma'am.
And it becomes the property of the general public.
No, that I don't think
There
not is
is
right.
in the 2007, my lord.
That is the list.
Allah, there
That's
is
going to be the issue.
That's the list.
2007, there is some amendment to the zonal regulation. As per the 2007 zonal regulation, the developers or the association, they can make the application for a BDA for maintenance of but ownership remains with the BDA. They can make application for maintenance of the park.
Who can access to it? Who can have access to it?
So there is no restriction for it is only for the extra. It was the zonal regulation says whether the residents or a welfare association or the developers can maintain that the park.
Not about maintenance, Mr. Krishna.
Yes.
Who can have access to these places? It speaks about road, it speaks about civic community, it speaks about park. I'm asking you, who can have access to it? Can general public have access to it or not?
The amendment is concerned, but there is no regarding that word is.
What is the position of law? Can general public have access to it?
Once a relinquishment, it becomes the public property, BDA property.
BDA property.
Then only we will, as per the zonal, modified zonal regulation, we can give only for the maintenance, but the ownership remains with the BDA.
Then can general public access to it?
That question, my lord.
You have to answer. It's your property.
Yes.
Who can access to it? Who cannot have access to it? You'll have to answer.
That
The
question,
intent-
to get the
The
instruction.
intent is that it should be rested with or relinquished to the BDA is for the public purpose only, not to have private ownership over it.
My lord, I must say one thing, my lord.
They can maintain it.
My lord, effect of this will become catastrophic, my lord.
This road is part of your apartment.
Yes, my lord. It is part of the apartment complex. As a matter of fact, my lord, in an apartment complex, tomorrow if I have a children's park for the benefit of the residents, the argument is anybody in the public can access it. If, my lord, there is an area where residents can walk inside the apartment complex, tomorrow, my lord, then say that even the basement we should be able to access.
How could it?
Because we have to enter the property through that. It is not as if, my lord, there is entry or right of access to any other route.
One of the judgment.
He-
Hmm? Yeah.
ಇದೆ ನೋಡಿ, ಎರಡು copies.
Public use.
May I pass on the judgments of this honorable court, please, my lord, on the same point. Division bench of this honorable court.
But Mr. Sinnapati's paragraph, page 11, 12, 11 photographs today.
Yes, yes.
Who has produced? Number 7.
BBM.
Mr. Sanjeev. has- Now this road appears to be quite away and outside your apartment.
No, my lord, there is a road which is at the periphery.
Very
The periphery, my lord, but that's the entrance to our entire complex. That road ends in a particular area, which is a nala, beyond which the road does not continue.
Your apartment.
This is the road that continues, please, my lord.
Your
One
apartment is a
second.
gated apartment.
No, our apartment, of course, is gated in the sense we have to enter, therefore,
Then this road is outside that case.
no, my lord. As a matter of fact, the road is the periphery. One part is the road, my lord. Now, entrance into our apartment is through that road. Now, that road is no doubt relinquished to the BDA. There's no doubt, we are not disputing all those positions. But what is the consequence of relinquishment? Is the consequence, my lord, that the road therefore becomes a public road, or should it be declared to be a public road? Because under the Karnataka Municipal Corporations Act, there, my lord, the law seems to be a little uncertain. I want to point this out. Why I'm pointing this out is there are, of course, apartments which are very large like this. There are also smaller apartment complexes which may have 100 apartments, which will have a park, which mandatorily must have a park in the middle, which essentially is for the benefit of the residents. If tomorrow it is said that because you've relinquished it, any member of the public can enter into an apartment, it will mean that the entire apartment becomes a thoroughfare for anyone to enter into the property, use any facility and amenity which is there. Now, that will not, quite apart from using a road, to then say you can enter into an apartment and then allow it for general public use would become a catastrophic problem for everybody across Bangalore, across every single apartment complex, big or small. And it is very easy, my lord, especially when my learned friend's property itself is after that. And the whole objective appears to be that they wanted to somehow attack this residential complex because their properties are after that and adjoining to this, not public interest. It is really in their interest that they are trying to do this. And respectfully, my lord, I'm only making this plea. Please look at the danger to those 10,000 people who are there. Absolutely no control, because these are not general open areas where one house is there, there's a road, police can enter, there'll be protection. Anything under the sun can happen there. And I have maintained this road till today. The Resident Welfare Association has maintained the road till today. BD has not invested a single rupee in maintaining the road. Now I maintain the road, my lord, and someone else seeks to benefit from it.
That is the condition, my lord, the condition of the, my lord, one of the judgment of the division bench of this honorable court says, my lord, it can be utilized by both the residents as well as public.
Yeah, please, my lord. The judgment.
WA number, my lord, the 61.
Judgment in mobile. You make your stand clear about what Mr. Chinnappa is submitting.
But this is a real problem, Lord. I'm not really speaking only of these. After all, your lordships will not in PIL today will be practically laying down the law for everybody. And tomorrow, every single association will have to open the gates.
What you are saying has dangers also.
I beg your pardon?
What you are saying has its own dangers also. So somebody may encroach upon the property.
Someone can encroach, someone can build.
No, you can encroach the association.
Well, I can encroach in the sense, Lord, I'll be using it as a park. Now, please see a situation, Lord, where someone else comes and
he has relinquished that part of the property, my lord. There is no question of him saying that it is my road.
no, I'm not saying it's my road. It's a big difference in saying it's my road and that the property should be used only as a road.
Yes.
There are two different things. A private street,
BDM, my lord.
I'm sorry, a private street, my lord, is defined in under the Municipal Corporations Act specifically. And under the Karnataka Town and Country Planning Act, a layout of private streets is what is contained in section 17. Lords may look at section 17. Lord.
Road is not part of the layout.
It is part of the layout. It is part of the layout. It is part of the layout.
Your own layout.
Yes, Lord. It is part of the layout.
Part of the layout, but it was relinquished to the BDM, my lord. It was one of the condition in the approving the layout plan that they have to maintain form the road and then relinquish to the planning authority.
So Mr. Chinnappa says that though it is surrendered to VDA, there is some limited extent surrender.
Lord, my respectful submission, Lord, is relinquishment is an incident of law. I have to relinquish.
It's in VDA.
My lord, if your lordships look at section 17.
Who is for VDA? You are for
No,
I am for
Mr. Krishna appear.
Make your stand clear.
My lord,
The effect of this relinquishment and.
So that has been dealt with by this honorable court, division bench of this honorable court, please, my lord, in the judgments.
You are public interest petition. Who are you? Who are you? I'm asking you, you're smiling. Who are you?
Petitioner, please, my lord.
That we know that, but who are you? What is your capacity status?
A public, please, my lord.
No, that is highly public spirited, but who are you? Resident or bypasser or?
They are living, they say they have properties adjoining to this
Yes,
property.
we have properties there, please, my lord. Behind that.
So
Then
you are also using this road?
Of course. Yes,
No,
they are using this road.
If
Then what is it?
no, if I apply for the development plan, please, my lord, if the development plan puts the condition that I must relinquish the road, I must relinquish, please, my lord. There is no exception for
That's not the
anybody,
point.
please, my lord. I have not applied for developmental plan. That is the condition precedent, please, my lord. Prior approval, prior to the approval, that is the condition precedent. Unless I relinquish the civic amenities, parks and roads, please, my lord, I will not be in a position to get the plan, please, my lord.
Well, in this question, my lord, I will get the instruction.
Get the.
But if my lord sees section 17, Lord, it uses the expression private streets.
Private street is defined always in municipal.
Yes, my lord. And then you can declare it as a public street, for which a separate declaration has to be made.
This is what, public street?
Beg your pardon, my lord?
This is public street.
No, this is according to me a private street, which is
How do you say that?
because, my lord, we form the road, we form the entire street, and then we hand it over to the BDA. The
So the formation of the roads, amenities, everything is done by us. We hand it over and relinquish it to the BDA. The objective behind it is to ensure that you must not subsequently use it for some other purpose. It should be used only for that purpose as a road. Now, my lord, the question is, how far can you go in saying that any member of the public can thereafter use it? To which, my lord, there are two answers in my respectful submission. One is, if your lordship's hold it's a public road, then of course not any member of the public can enter the property. But if it remains a private street, under the Municipal Corporations Act as well as the BBMP Act, there is a process of declaration of a private street into a public street. And if you follow that and declare it as a public street, it is one thing. And secondly, my lord, under the zoning regulations, all civic amenity sites and parks are allowed to the users, that is in the residence area, for them to utilize that property. Now, my lord, these people who adjoin this building now want to say, I want to come and utilize this property. Now, how will you come, my lord? I ask myself, you have to pass through my property now. It is not as if, my lord, that the parks are open for anyone to enter without entering upon my property. Now, am I then entitled to say, I will not allow you to enter upon my property, but you can go some other way if you can reach the park? I can prevent a person from entering my property. No, the relinquishment does not mean, my lord, then they'll have an easementary right in respect of my built-up area to enter into the property and go to the park. And this, my lord, will have disastrous consequences across Bangalore. I mean, Bangalore, Bombay, or any other place. In Bangalore, my lord, the consequences will be so severe that every single apartment complex, I can walk in and say, I want to use your park today. And walk straight in and say, I want to use the park today. And tomorrow I'll go to the next apartment complex. I want to use the park on the next day. And then your lordship will see these apartment complexes will never be livable at all.
Let him.
I will get the instruction in this point.
So your lordship may kindly see, as per the zonal regulations and as well as comprehensive development plans, time to time the BDA will prepare, please, my lord. As per that only development plans have to be sanctioned. From 1984, BDA has been, the comprehensive development plans are being prepared by the BDA, please, my lord. So 2001 EAD BDA CDP shows this road as a public road, please, my lord. And 1995, that is 2011 comprehensive development plan also shows that this property, this road as a public road, please, my lord. And as per that only, they have relinquished the roads in favor of the BDA, please, my lord. I have produced these documents at Annexure B2 and B1, please, my lord.
When shall we keep 31st January?
So, 230.
So, learned advocate Mr. B.L. Sanjeev files statement of, today you filed?
Yes, I also.
Statement of objections on behalf of number 7. Seventh response. Along with the photographs, which is taken on record.
First respondent also filed the affidavit, my lord, compliance of the last direction. Compliance of the direction of the last hearing date. First respondent also filed the affidavit.
You have filed it?
Yes, I already.
Also filed is the affidavit by
First
respondent number
First respondent.
1. Appearing through learned advocate Mr. Swams. Which is also taken on record. Learned advocate Mr. BDA wants time to take instructions. Stand over to 31st. Wait.
Number 73. Mr. Shivkumar.
No, my lord. This is a matter of counterfeiting of stamp papers, and the state had filed an affidavit on 19 November stating that they will file a detailed report for having taken action, my lord.
My lord, could I seek for 2 weeks' time, my lord, for the report to submit the report?
Then submit it. This is second time you are asking.
Yes, I apologize.
19th, 20th February.
Obliged.
Number 74.
Appear for the appellant, my lord.
This matter, yes. Served a copy on me, my lord. My name was not shown. I never knew, my lord.
My lord, the writ appeal where there was 48 days delay, matter had come up for last Thursday. This honorable court directed me to serve Mr. B.L. Sanjeev, counsel appearing for BWSSB. This is
That when it is coming,
My name was also not shown. That is what he says.
other connected matter is also
yes, my lord. It is tomorrow.
tomorrow.
Appeal number.
This matter, my
I'll give the
name may be
appeal.
shown. My name may be shown.
Send out to tomorrow, name of learned advocate Mr. B.L. Sanjeev, appearing for the respondents will be indicated. Support.
My lord, directed writ appeal is 867 of 2024.
8,
Writ appeal 867 of 2024.
857.
867.
67. Writ appeal number 867 shall be listed today.
Number 75. Mr. Sheshadri, yes.
I got information from respondent number 5 that appellant is dead, my lord.
What is the urgency?
And my lord, appellant is dead, my lord. I'll have to bring their laws into record.
Time to bring on record the heirs of the deceased appellant is granted. Stand over to 25th March.
Number 76. Mr. Rahmatullah Kotwal.
Appellant in this case, your lordships. Challenging the order dated 27/8/2021 passed by the learned single judge, your lordships. Lordships, petition was dismissed, enlightening the reason that there was a delay of 34 years, your lordship. The original grantee was granted the land.
You
He
are
did-
original.
I'm not the original grantee. I'm the grandson of the original grantee, your lordship. Your lordship, the application before the assistant commissioner was made by the present appellant.
Grandson always looks like grandfather.
Your lordship, the original application was not made by the original grantee, your lordship. It was made by the present appellant. The learned single judge, your lordship, in pointed out that the application made before the assistant commissioner was made by the original grantee. It is not the case, your lordship. Before making that application, original grantee expired earlier to that application, your lordship.
Delay of 35 years.
Please. 35 years. There is no delay in fact, your lordship.
Even the transaction is not violation in section 4(2) of the Act, my lord, because land was sold before the Act came into force. After my lord's completion of the non-alienation condition of 10 years, that is the observation made by the learned single judge.
Your lordship, the section 4 of PTCL Act specifically says, clause 2 of section 4 specifically says that no person shall, after the commencement of this act, transfer or acquire by transfer any granted land without the previous permission of the government, your lordship. It was sold without the permission of the government. And subsequently, section 5 speaks about resumption of restitution of granted lands. Here, this particular section doesn't specify the limitation period, your lordship. Clause C may kindly be perused, your lordship. Notwithstanding anything contained in any law, there shall be no limitation of time to invoke the provisions of this act.
Correct. That's all. That's all.
Please, your lordship.
Several orders are passed, dismissed.
Much obliged.
Several appeals are dismissed by now. You go through those orders.
Please, please.
Yes.
Number 77.
Nobody, the delay of 447. Is also Nikanti. Same. Nikanti, 35 years.
35 years here.
33.
35 years again here.
Delay is there, but not there. Give a chance to, since learned advocate for the appellant is not present, stand out to 5th of, not 5th of, 4th of February to be listed at 2:30.
This is number 78 to Maruti GB.
Here for the petitioner in this matter. My lordship, there is some personal inconvenience. Kindly, I will come next week.
Same.
Any date. Please, my lordship.
Same.
R. Raghavan.
No, this is different. No, it's same, mister. Who are you? 17 years still. It must be attached to the purchase. Who are you? Purchaser? Who are you?
Purchase.
Purchase?
Next. I have it on next.
Once you say, we pass the order.
Lordship, kindly have it on next week. Next week, any date. my lord.
Next week. Why? Some material instructions is to be taken. Material instructions remains to be obtained. Why? Why next week? Several appeals are disposed of. We'll give read appeal number 210 of 24. Go through the judgment. Read appeal number 210 of 24. 23. Tomorrow at 2:30.
Number 79 to Srihari.
I appear for the appellant's counsel. The writ petition of the grantees are dismissed. Like, the writ petition of the purchasers are dismissed, but the direction is given. Kindly see 111. What has happened is possession was delivered to me after the order of the Assistant Commissioner and the Deputy Commissioner, except 35 guntas. When the matter came up for hearing, the learned single judge asked both the parties to see some equities to be adjusted, etc. Then we made a submission in respect of that 35 guntas. Whoever has put up construction before the order of the Assistant Commissioner, their constructions may be allowed to remain. But now an order is made of general nature that purchasers who have come up to 22, they may be allotted site, etc., which is, and it's not on our concession now. It has been made as if an order of the court. Taking advantage of this order, now new writ petitions are filed.
saying we also should be given the same benefit.
Then there is a delay of 447.
Yes, my lord. The other side filed a review petition. Initially being spoken to, thereafter a review petition. After the disposal of review petition, we have filed the appeal. There is a delay of about, if review petition is taken into consideration, there will be a delay of 4 months.
Review by other side.
Review by other side.
Review by others can't give you the.
Of course, my lord, because that was pending, we did wait. Our difficulty is, as regards that 35 guntas, we did concede that whoever has put up the construction may be given at present market value was our submission. But now the order is made not on concession. It has been made as court order. Now fresh petitions are being filed by others saying the same benefit is to be given.
We'll just go through. If it's thing on 6th of February.
Please.
6th of February, we'll go through. You for it.
Judgment. Shall I take out notice to the other side?
This is not issued? No.
No.
Then we'll issue notice. Notice returnable on little 11th February.
Please.
Notice. Notice in both appeal and.
Please.
Much.
December 36, Mr. Anand Kumar C.
Lords, this matter, we are on the process of compliance, my lords. There is a mismatch of extent of land in column number 6, 3 and 9 of the RTC.
They have mutated
So-
the adjacent landowner's name, which was
Yes, we
produced even before the writ petition, my lords, for the single judge. 84 is conducted, 87 is conducted, 86. Mine is 85, my lords. Only my land is not mutated by them.
So that needs to be corrected. Some time may be granted.
One day it can be corrected in one day.
I acquired the title by virtue of the judgment passed by the trial court, seeking relief of declaration.
Can it not be corrected in?
But we have to send it to the higher authorities, take the permission, and then correct it, my lords. Podi and Durasti or physical work is also required. Thus, we are on the process of compliance, my lords. Some time may be granted.
Lord single judge directed the respondent Tehsildar Bengaluru North Taluka to. This is Podi and Durasti.
Yes, my lords.
To undertake the process of Podi and Durasti
And mutation entry.
and mutation. In light of
Mutation
the
entry.
decree passed in the original suit number 9572 of 1998 by the civil court to complete the exercise within the time stipulated. Learned paragraph. Addition government advocate Srimati Pramodani Kishan, when the petition came up for consideration, submitted that the directions are in the process of compliance. And that since there is a mistake occurred in mutating, the same is being corrected by referring the case to the higher authority, full stop. It is expected that the compliance will be done, and the name of the petitioner shall be mutated by correcting
Lots.
the error
Some time may be granted, my lords. We have
With-
sought the,
within 10 days.
lots,
Within how much?
at least 4 weeks, my lords.
On or before 27th February.
Obliged.
Send out to 27th February. To be listed at 2:30.
Number 37.
Lords, I appeal to the petition.
Lords, in this, DPC has been conducted, my lords, on 15th. Lords, now the proceedings have to be drawn, my lords.
Please
Yes.
grant time.
Please, my lords, because we have to issue the, my lords, once we receive the
Homogenization,
directions
that
from the
the
medical education
sections are
secretary,
under
we are
compliance
supposed to
and
give him a.
necessary
motion now.
compliance we will file before the next date. Stand over to 20th February.
Much.
Obliged.
But do that, we are granting longer time so that you need
Obliged.
not
Will.
again ask for time. Yes.
Number 38, the Sarup. I appeal for the petitioner in this matter.
Respondent will undertake to file power on behalf of the accused.
There's a writ appeal.
The writ appeal is
Is it
on board
already-
today, my lord, serial number 62. It is a stay granted this honorable court, my lord.
So no.
This may be taken up along with the writ appeal, my lord. It may be connected.
First week of February, my lord.
Inner council is on its legs. While the serial number 62 reaches, we'll make
The
submissions
order
on both
under
the matters.
contempt. The order brought under this contempt petition. It stayed by this court. Can you read petition number
1318 of 2020,
1318 of
1318 of 2024?
which is the serial number
As per the
62
order
today.
passed today.
The matter is listed today, my lord.
today, my lord, at serial number 62, it is listed.
order. Today it is listed because.
Yes, it is on
then
board.
wait, then
Fine,
wait,
that's my submission.
then wait.
Number 39, to B Ramesh.
Lords, writ appeal has been filed in this matter, my lord.
My lord, there is an order passed by this on a single judge to release third phase site, 30% sites within a period of 4 weeks, my lords. November was the order, September was the order, my lord. 5/9/2024.
Learned additional government education promoting education stated that writ appeal is filed with respect of order dated against order dated 5th September 2024. In writ appeal number 25302 of 2023, which is the subject matter of the present contempt petition. In that view, the hearing of the present contempt petition is deferred to TO2. 21st February.
My
It is observed that
My lord,
before
second
which
week of February, for this reason, my lord. My lords, the sites have been, agreement of sale has been executed in favor of the prospective purchasers. My lord, layout has been completed in the year 2019. My lords, I am not able to execute the sale deeds. My lords, first week of February, my lords.
before which date the appellant state shall ensure that the appropriate orders are obtained in the writ appeal, failing which the order shall be executed.
Obliged.
Yes.
Regarding the layout is completed on the year of 2023, my lord. Thereafter, my lord, you approach this honorable court, my lord. That is the reason my submission. And also, my lord, the notification quashed by this honorable court regarding, my lord, the penalties concern. That is the reason, my lord, they filed, state also filed the appeal, my lord. That regard, my lord, we can't execute the order of the single.
Lords, planning authority has to release the sites, my lords. They have not preferred any appeal.
No, so our direction is for the planning authority. But state has preferred the appeal, my lord. But planning authority is the direction is on the planning authority, my lord. They have not filed.
For notification has
Yes,
been quashed.
Notification is quashed, my lord. The order of learned single. Notification is quashed and 80 sites are directed to be ended.
Yes, my lord. 30% of the sites has been directed to release and by.
Let them test in the appeal.
Number 40. Azhar Ali Farooq.
For the petitioner in this case, no, sir. Order of 12th July 2024 is being violated continuously, Your Lordship. Page number 33 onwards, bottom of the page. The child was to be sent, the elder one was to be sent on Saturday and to be brought on Sunday morning. And the second child being too young, it was for daytime only. However, this order is not being followed, Your Lordship. In fact, pursuant to this order, they filed another writ petition challenging a joint order that is on page number 36. Operative portion is at paragraph number 4, wherein they had undertaken that they will abide by this order, and accordingly they were permitted to take the children out of Bangalore for a brief period to Mumbai and Goa. However, and I was given an additional visitation saying that for the remaining of the days, I will be entitled to have the custody of the children. That was also not followed. Subsequently, there was an order passed by the family court stating that you can have children for the Diwali vacations. The operative portion being at page number 46, Your Lordship. All these orders are being violated. In fact, they filed an application on the ground that the child is not willing to go. They filed an application for modification. That application came to be dismissed. As on date, this order is in force, Your Lordship.
Lords, may I urge your lordships to just turn to page 82 of my objections reply, lords?
I have not received the objections.
I have served it. Without, this is his copy. It's on the mail.
I have not received it.
It's on the
How
mail.
you are receiving?
I require time to go through this. That is the case. In the meantime, let they comply by the order during this weekend, Your Lordship.
May I just,
Pass it. Where is it? Is filed?
my lords, yes, it's filed, my lords.
Petitions are-
It's filed on Friday itself. Thursday, right?
In fact, all these contentions from the index that I can see, all these contentions were considered in 2819 in the modification application.
Your father.
I am for the farm.
Yes. Amount is paid 1,25,000.
Till now, 25 lakhs I have paid, Your Lordship. In fact, only even if they say there is any amount disputed, I am ready to deposit that as well. In fact, there was no order as to educational expenses. I have paid that as well. I am a cancer survivor. 23rd March 2023, I was having my brain tumor surgery, cyberknife surgery. It is at that time that she left me. And since then, I have been dwindling between one court to another to see my children. In fact, observer was appointed to see how my conduct is. Even he gave a favorable report. Pursuant to that, I got an order of 12th July 2024, Your Lordship. Then they say, no, you meet me outside at Bangalore Club. You meet at a place, at this place, that place. I said, no, when there is an order, you please abide by it. That is what I am saying. Not that I am very happy with the order. Even I wanted more custody. In fact, I said, if there is an order, let that be followed.
May I?
What is the reply?
Your Lordship?
What is your reply?
My lords, in my reply, I'm not sure if it's on board, my lords.
It says not filed in the.
82 page number. Similarly, for sought in a habeas corpus petition by this very complainant. Similarly, after initiating this contempt proceedings, which was pending before a coordinate bench, and just last week, my lords, on the 15th, the bench felt that definitely since custody proceedings are already pending, that is where the party has to approach. However, the court does not mind interacting with the parties and seeing if this thing can be arrived at which time complainant sought to withdraw the petition. Now that was the second habeas corpus petition that was initiated. Well, still today, the complainant is not before any courts to even consent for a mediation process.
Your Lordship, in fact.
This, may I? Well, this maintenance amount, which has attained its finality by virtue of Supreme Court order dated 16/1/2024, has never been adhered to. Even as of I'm submitting that there is an amount of 5 lakh rupees pending from the complainant. And the order itself says, if the complainant does not pay the maintenance by 5th of every month, he is not entitled to have the custody of the children. And it's not as if he has not been exercising his visitation orders, my lords. By virtue of orders passed by family court in various applications which have been filed by him, he is visiting the children. In fact, from 23rd to 27th, the respondent herself has taken the children every day to his house from 10 o'clock to 6 o'clock to make sure the father spends time. However, the only grievance that he has is my innocent has to spend overnight and the child is refusing to go. And this contempt petition has been filed on the 11th, when modification applications were filed even by the complainant and the respondents, and orders were not yet passed. And it was only on 29th, 11, all the applications passed by the parties were dismissed. However, the complainant preempts and files the contempt petition on 11th of November. Post that, he files a habeas corpus petition, a second one. Completely aware of the fact that there is a custody petition that he has filed, not me.
Your Lordship, order dated
That-
110.
I've not finished. The order of the habeas corpus, in the habeas corpus petition, my lords, the earlier one, I have produced it at annexure 4. Annexure 5 is the Supreme Court order. Annexure 6 is an order in the WP that was filed by me seeking permission to take the children out. From the time of throwing me out of the matrimonial home, barely when my second child was 10 months old.
You go through.
Yes, sir.
You go through the.
I'll go through, Your Lordship. And in fact, for proof of payment, I'll produce all the proof. Till now, 25 lakhs I have paid. Your Lordship.
Today you are abroad or you are here?
Your Lordship?
You are staying in India?
I am staying 2 streets away from her house. In fact,
You are serving.
My lords,
You are serving, earning.
I didn't get
The
that.
mother is serving somewhere.
No, no, my lords.
No.
Mother, the children are with the mother.
Mother is serving somewhere.
No, my lords.
to my knowledge, she is, sir.
She's not.
To my knowledge, she is working.
In fact, her second child is only 2.5 years old.
In fact, all these contentions, I'll go through it and I'll respond.
You can send the children to the father in this weekend.
My lords, that is exact. The email communication, my lords, what has happened is from 10 o'clock on Saturday morning till Sunday morning, the first child has been granted. However, what I suggested is, since the boy is refusing to stay overnight, considering that he's only 5 years old, I'm okay to take the child and spend from 10 o'clock to 6 o'clock, as was during the Christmas vacation. That's what happened. No, they say no. We do not want.
Just to
Even
point out,
writ petition filed earlier by him itself, when the court ascertained the child was only 11 months, barely 11 months old, the court said every day he is allowed to visit the children at my house. Not a single day he came for a year. Not a single day.
I will seek instructions on that suggestion. However, I'll seek instructions from my client on this. However, to point out the mischief, what has happened.
But is it correct what the council says?
Mm,
Used to, whenever.
No, she is giving me options. I said there is an order. All these options were placed before the honorable single judge, learned single judge as well.
Spend whatever time you can spend with your son. From 10 to 6, they are ready.
I will seek instructions on that. I'll seek instructions on that. Your Lordship, I'll seek instructions. However, the child is not refusing because there was an overlapping day of Saturday. Saturday, they were supposed to send me this winter vacation. They don't send the child on Saturday saying that the child will stay back. Child is very much eager to stay with me. In fact, child was interviewed by the learned single judge. He ran away from the mother saying that I want to go with the grandparents. This is the bond that the paternal family is having with the child. I'll produce all the documents. I'll go through this, I'll respond, and in fact, I'll produce the proof of payment as well.
But they can come to your house from 10 to 6 this Saturday.
I will seek instructions. I will seek instructions. This week, anytime before it comes, I'll seek instruction, I'll get back.
Not this week, Milods.
Today is what? 30, January to 30th January. 30th January.
Grateful.
In this week also, if it is done, I'll take instructions.
We are giving so many options.
I'll seek instructions on that. 30th, I'll come back.
Great.
Number 41, Mr. Raghunath, MD.
Here for the complainant, please.
Yeah, paper, 1, 2, 3 to 5.
Not done. The order of the learned single judge is at Annexure A, page 8. Lord, may kindly come to page 10. Para 4, please, Mila. Para 3. Learned Counsel for Respondents 3 to 5 have filed an affidavit of Respondent 3 and 4, stating that confirmatory order under subsection 3 of 248 of BBMP Act having been issued. An appeal in relation thereto has been filed under section 253 of BBMP Act in appeal number 184 of 23, which is pending consideration before the Chief Commissioner and now posted on 16/12/23. A further undertaking has been made by the respondents 3 and 4 that during the pendency of the appeal, respondents 3 and 4 will not undertake any further construction except interior works. However, I am of the considered opinion that once a confirmatory order has been passed, the question of carrying out any construction activity, including interior work, would not arise until the construction is brought in accordance with the building bylaws and/or the plan sanction. In view of the matter, the permission for carrying out interior works is refused, since action has already been initiated by corporation under section 248 of the Act, and an appeal is still pending. The decision of Chief Commissioner will be binding on the parties. But subsequently, my lord, they did not keep quiet. They started doing the interior works. I have produced the photographs at Annexure B series, please, my lord. I also gave a representation to BBMP at Annexure C on 6/1/2024, bringing to their notice that this is the violation which they have done. My lord, the BBMP keeps quiet and I filed the contempt before this honorable court. My lord, in the first instance, this honorable court directed me to delete BBMP commissioner, that is respondents 1 and 2 before this honorable in the contempt proceedings, as appeal is pending before the Chief Commissioner. Lord, subsequently notice has been ordered. They file an affidavit saying that there is no violation. Lord, and they also produce the Chief Commissioner's order saying that their appeal is partly allowed. My lord, if may kindly take their objection statement. The order passed is dated 17/2/2024. Lord, at internal page 6, please, Mila, of their objections. This is what it reads. Adesha. ಮೇಲ್ಮನವಿಯನ್ನು ಭಾಗಶಃ ಪುರಸ್ಕರಿಸಲಾಗಿದೆ. ಎದುರುದಾರರ ದಿನಾಂಕ 26/6/2023 ಸ್ಥಿತೀಕರಣ ಆದೇಶ ಸಂಖ್ಯೆ ಸೋರನ್ನು ರದ್ದುಗೊಳಿಸಲಾಗಿದೆ. ಮೇಲ್ಮನವಿದಾರರ ಕ್ರಮಬದ್ಧವಾಗಿ BBMP ಕಾಯ್ದೆ 2020 ಕಾಲಂ 248(1), 2 and 3 ಅಡಿಯಲ್ಲಿ ಕ್ರಮ
ಕೈಗೊಳ್ಳಲು ನಿರ್ದೇಶಿಸಿದೆ. ಸದರಿ ಆದೇಶಗಳಿಗೆ ಮೇಲ್ಮನವಿದಾರನ ಆಕ್ಷೇಪಣೆ ಪ್ರತ್ಯುತ್ತರವನ್ನು ಸಲ್ಲಿಸಿದಲ್ಲಿ ಕೂಲಂಕುಷವಾಗಿ ಪರಿಶೀಲಿಸಿ ನಿಯಮಾನುಸಾರ ಕ್ರಮವನ್ನು ಸಹಿಸಲು ನಿರ್ದೇಶಿಸಲಾಗಿದೆ. Lord, the Chief Commissioner passes an order directing their authorities to follow section 248, 1, 2, and 3 by allowing their appeal only in part. In the sense, my lord, that their construction is still illegal. They have not demolished it, please, my lord. Lord, I am given to understand subsequently also on 21/10/2024, I could secure RTI copies of the directions of the BBMP. They had issued notices dated 3/10/2024, holding that 248, 1, 2, and 3 are issued afresh, please.
That the single judge, my lord, that it myself is undertaken that I will not construct till disposal of the appeal. That appeal is disposed. The setting aside that so far as that earlier order which has been 248 as well as 1 and 2. Liberty given to the authorities to proceed further. Not that till that, that where that their contention is that we have, that it is we have disputed, we are not commenced. Like the 17/2/2024 itself, that order has been set aside by the Chief Commissioner. That our undertaking before the land single judge is still appeal has been filed against the order of the 248(3). That appeal is pending. Till disposal of the appeal will not so far as that it is in a construct. The appeal is now that it has been allowed. And further procedure remitted back to the authorities to reconsideration.
It is through 48 proceedings are over.
They have to initiate 248, 1, 2, 3, and notices are issued, my lord.
Again,
Only
after
thing is
remitted
demolition
back to
order.
the Chief Commissioner, that the further proceedings has been conducted. That as notices have been, it has to be conducted in accordance with law. That first, that when that 248(3) order has been passed, that has been the implementation writ petition is filed. I have filed an affidavit saying that I have already agreed and filed an appeal. Appeal is pending till completion of the appeal. I will not so far as that in a further construction. So the appeal that where that order in the earlier passed 248(3), which has been
that appeal is partly allowed. Subsequently, my lord, there is one more set of notices issued. Not, I'll have to get a new cause of action. I'll have to file one more writ petition and come back before. That will be second round of litigation. Or if my lords permit me to revive the order wherein I was permitted to delete respondents 1 and 2 to be restored as respondents 1 and 2. Then, my lord, true picture will come to the light of this honorable court, because their unauthorized construction is still in existence, which is to be demolished.
So there is no contempt. What is the contempt?
Lord, as on the date of filing this petition, they had already committed contempt, because kindly see the photographs which I have produced at page 13, please. With the dates, I have clearly mentioned that they are still doing the interiors. Interior works which they were prohibited to do. The order of the learned single judge is 4th December 2023. The photographs produced by me are 29/12/23, 1/2/2024. Which clearly show that still work is in progress.
Grievance of petitioner complainant before the honor single judge was that two corporation did not take any action against the private respondents with regard to the alleged illegal construction carried out by them. So that petition was disposed of by the honor single judge. He put the last two paragraphs of the order stated 4th December 23, from which this contempt arises, reads as under. On page. This is page 4. Sorry, page 10, paragraph 4 and 5. The full paragraph, learning up to quoting. Learning single judge reports permission for carrying out interior works. Since the action under section 248 of the BBMP Act has already been initiated by the corporation, and the appeal in that regard is pending. Observing further that the decision of the Chief Commissioner shall be binding on both the parties. Full stop. No contempt is made out in respect of the above order. Contempt petition is misconceived. It is
With the liberty at least to re-agitate against them in a fresh proceeding.
After this decision comes, no?
Yes, please, but the fresh notices are issued.
Goes without saying that the decision in appeal would be challenged by the petitioner if aggrieved on merits in accordance with law.
Symbol 42. Issue Baba.
10th March.
Symbol 43. 43, my lord, and affidavit has been filed, my lord, which appears to be incorrect, my lord. There is a positive direction to enter the name of the petitioner in the RTC, my lord. However, an endorsement has been issued by the officer rejecting the request of the petitioner, my lord. We will rectify the process, my lord.
When you will rectify?
We will withdraw this compliance affidavit and we will, 2 weeks time we will do.
That may kindly be recorded, my lord.
Learned advocate
Because it's against the directions.
submits that the present affidavit, present compliance affidavit may be permitted to withdraw.
Please.
And they will comply with this.
It is so permitted.
They will comply with the.
We'll comply with the order.
If advised, the fresh affidavit may be filed.
Please.
Before the fresh affidavit may be filed before the next date.
No, my lord, they are saying that they will comply.
Upon-
That may
When
be-
shall we keep? 18th?
We'll file an affidavit, my lord, within 2 weeks time, my lord.
18th February.
Please. my lord.
Great.
Number 44. Okay, Nisha S. Kumar, 14%.
One submission, Lords. This contempt is as against the interim order that was granted, not in the MFA. Lords have interim order that was granted, not in the MFA. The contempt is as against it. Lords have already held, not in plethora of not orders that whenever the interim orders are passed, not it has to be before the same court where the matter is pending.
This is interim order.
Yes, Lord. The matter is pending before Lord the division bench of the Sovereign. In fact, Lords had passed an order, Lord, on 1st of October.
Regarding that report obtained, etc.
Yes, Lord.
My lord.
110/2024 is my Lord's order.
So,
110/24.
Panchayat shall provide the water connection upon payment of necessary charges.
But that is,
So we ended there and we end there.
yes, Lord, that is not Kotekar Town Panchayat. Kotekar Town Panchayat, I think, Lord, my learned
I
friend-
represent the third respondent, my lords. But as a matter of fact, my lord, we have already informed her that an application has to be uploaded through online portal. And unless the application is uploaded through Jalanidhi online portal, my lord, we are unable to process it. Because, my lord, stage by stage will have to be processed. Then, my lord, it has to be submitted by the owner of the building, enclosing the relevant documents. Therefore, my lord, the complainant has filed a memo
seeking a direction, directing the accused number one to make such an application. So once an application is made, we are required to not provide the water facility because there is no water supply from the town panchayat because they have been using the water from their own borewell, the entire building.
You will provide.
An application will have to be uploaded.
That is what we have observed.
Yes.
Provided.
Want an application filed by me, my lord.
If I may
It
be
is not
permitted,
that the first respondent accused, they want me to file the application for water connection. But my only difficulty is not I have filed an application for recalling of this order, but without prejudice to my rights, not may say not I will make an application.
Recalling of 11025.
But this very order not which is passed, saying that not this in the MFA, wherein not the order was passed saying that not I should provide this residence.
Against the order of learned single judge.
Let's say division bench not in the MFA, the order which contempt is alleged, that an application is filed before the very same bench seeking for recalling. But without prejudice to my rights and contentions, not may direct me not to, or not I'll make an application not for water connection. No, I don't want to stand on all these technicalities.
if I may.
That
be
is what
permitted-
she has filed a memo today, saying that not I have to make an application to the authorities, I will do it.
Your landlord.
But I am her husband.
Husband whose name not the.
If I may be permitted to assist the court, my lordship, I may want.
Property belongs to.
Please, Lord. But this property, Lord, it's her property. Lord, what has happened is, Lord, there is a settlement deed that is executed between the parties. That settlement deed, Lord, was subject matter of challenge before the civil court. Lord, the civil court, Lord, declared that insofar as, Lord, the settlement deed is null and void, not binding. This property is
Whose property? Your property.
It is my property, my lordship.
You file application to water connection.
My lordship, I would like be permitted to file this memo. This is the representation received from the panchayat, where they said that the property, although being mine, the door numbers have been given on my husband's name wrongfully. Now they want him to file an application pertaining to the water because my lordship has passed an order regarding that water. But I would like to bring the attention of my lordship to the ACP's report that was submitted by the accused number 2. If my lordship may kindly take that report. On page 26 of the report,
Why can't you file an application? What is preventing you?
my lordship, I have filed an application. That's the reason why I'm filing. Oh, I have filed.
They
an
are stating
application.
that you have not filed the necessary.
My lordship, I have submitted a copy of the application submitted to them.
You have to submit it
I've
online.
submitted an
No,
application.
you have to submit it in online. That is what they are saying.
For that, they require that the door number on whose it is, on whose name the door number is, they have to file an application.
You
This is
give
their
necessary
representation.
instructions, she will file the application.
Lord, she has not uploaded the application or filed the application through online Jalanidhi portal. Lord, the portal has been created, Lord, to facilitate the occupants to get the water supply. Once an application is filed along with the documents required, uploaded, Lord, it is our duty to process. Lord, since the documents are standing in the name of owner, not the husband of the accused number 1, Lord, he may have to file an application. That's what the
My lordship,
complainant says.
what they say is that my husband has to file the application. That's why my request before this honorable court is if he is directed to file the application, the water connection might get connected. But I would like to bring this order, the order or the report by the ACP, where it says the overhead water connection pipeline has been damaged by my husband.
Both of you undertake that she is the owner of the property?
Lord, what? No, Lord, what
You
is-
just now made a statement.
Yes, Lord. Now what? Sorry, pointed out, Lord, there's a suit that was filed by her. There's a settlement deed executed. That settlement deed note she had challenged. And that there the court held that the settlement deed is null and void. And therefore, Lord, the court said that not I don't have a right over the property, but not in there is a factory, etc. in the premises. Court said not she cannot take possession of the land. Now she has filed an appeal challenging that order.
So have I not filed appeal because a settlement deed that is executed. Therefore, not without getting into any of it, not I'm making a statement that not without prejudice to my rights and contention, not I'll make an application. I don't want to stand on technicalities. Not.
My lordship, the
But
order.
ultimately, if she's going to get
the
water,
order
in
of the
fact,
Division bench clearly says.
That you agitate in those
yes,
matters,
Lord,
counsel.
we will agitate there.
My
I
lordship,
don't
it
want to
clearly
not
says that
bring
no
everything
dispute
here.
that I am the owner of the property. That is not in dispute. The order itself is very clear about it. So now he's making the submission that.
That will be decided in those proceedings. We are not recording the same over here. But anyway, irrespective of who the owner of the property is, because certain revenue documents are standing in his name, right?
Yes.
The
Yes.
panchayat by mistake has written the door numbers on my property on his name, which
Okay.
was asked to be corrected,
Hmm.
but they have refused to correct it till date. And I have filed a
Why
complaint
they'll
pertaining to
direct-
that. So if it can be directed for him to file the application, I would be able to get at least water connection.
Lord, you have filed application,
Please, Lord.
application you have filed?
For the
Not yet.
panchayat, my lord, no, no, no. They have given the endorsement now, but I'll make an application. But may make one suggestion, not if subject to lord's feel. But to avoid all these controversies, Lord, if she Lord resides, she's already residing in some other house. Now, Lord, I'm ready to pay about 15,000 rent. Lord, let her take some other apartment or stay there. Therefore, this problem itself will not come because Lord, I am also staying in this very same locality or not very same compound. So there is not bound to be not some kind of friction. Of course, not the order of the court is to the effect that not she has to reside in this place. But as a suggestion, Lord, I'm making note so that the friction will reduce, subject to what my lords would say.
My lordship, my property is totally different than his. If he wants, he can avoid coming. He's not even in India for the moment. From 2022, he's out of the country. He is not in India. He's not staying there. Just to harass me, he has damaged the water connection. There was water connection, borewell connection. Panchayat has clearly mentioned in the report. And the ACP has clearly mentioned in her report, saying the pipeline coming from the overhead water tank to the particular house has been damaged. The rest of the building is getting water. So he's wantonly harassing me from not entertaining my own property. That is the property purchased by my dad for me. He fabricated a settlement deed, forging the signature on a GP and transferred the property, which was nullified by the family court. That's where it stands. The property is mine. I shouldn't be asked to leave that premise and go. And he cannot violate an order of the court. He gives an undertaking before the domestic violence court saying, I'm giving her a fully furnished house. He provides photographs, almost 40 photographs of a 1 BHK with 5-5 angles showing the fully furnished house, my lordship. I have produced the photographs before my lordship. It's on page number 94 of my petition. It runs all the way to 140. These are photographs which he's produced before the trial court to get an order to move me from the matrimonial house, which was a 5-bedroom palatial bungalow, to 1 BHK, saying I'm giving her all the amenities. Then gets an injunction from the family court, doesn't allow me to enter that premise for 12 years. Now, when the Honorable Division Bench has given me permission to enter and reside in my place, he robs all the furnitures. I have even produced photographs exactly how he's robbed all the furniture of the premise. He's damaged the water pipeline. He's got his uncle's cousin brother, my lordship, if you, page 94 to 140 are the photographs of what he's going to provide me. And if my lordship takes page 192, shows the vacant property. He's removed every single furniture from the premise. And then he gets his cousin to come and vandalize my property and sit in my property and threaten me by filing criminal case against me. To that extent, he has gone. The Honorable Court had given me permission to enter through gate number 3 and 4. He changes the gate numbers not to give me access through gate number 3. For reasons best known to him, it is the gate on my property. What is stopping him from allowing me to enter my own property? This is a clear violation of the division bench order. And he goes before other courts saying that I'm providing her a house, I'm providing her a house, she's not coming from Bombay. I've been harassed all the way from 2011, I'm coming from Bombay with my mother. I ended up in paralysis because of this. He files false cases. Every order of the court is being violated. I have to come before a contempt court. This is not the first time I have come before the contempt court. Even maintenance he was not paying. A mere 12,750 is the maintenance that was granted to me. Till it reached 17 lakhs, he didn't pay the amount. I have to file an execution case. I have to file a recovery case. This kind of a torture he is giving me. My prayer before this court, it's an order of the division bench. Even though it's an interim order, it's an order that had to be complied by him. He cannot be allowed to violate such an order and get away with it.
The order.
The order of the division bench is on page 24, my lordship.
That's at page
And on page
24.
26, first para, if I'm permitted to read. If my lordship can see, the division bench has also recorded the conduct of the appellant before the court, before passing an order. If I'm permitted to read the order, my lordship. The matter was called up.
There is an issue, this property itself.
I may read the order, my lordship.
In view of the file, in view of the fact recorded by learned advocate, learned single judge in his order that the respondent
Division
is
bench.
the-
Division bench.
of the division bench.
Please.
That the respondent is the owner of the house which is on dispute, comma. Respondent, there's petitioner here. Is the owner of the houses, is not in dispute, comma. I propose the order dated 1/10/24. The petitioner owner shall file an application.
But I'll file the application online.
In the facts of the case, the
Please.
your code number,
But I am for accused number 1.
number 1 shall file an application for restoration of water before the panchayat. In light of the order dated 1/10/20.
My lordship, even the
Lord,
pipe connected
I-
which he has damaged from the overhead tank to the house may be directed to be corrected.
But
Because
there,
he wantingly damaged it. It's in the report of the ACP.
but there's some difficulty. What she has done is not, she's taken possession not of the property on 9. 10th, not she says pipes are damaged. I was not in station at that point in time at all. She files a complaint, FIR is registered and charge sheet is filed. But any observation that is made, Lord, in this matter, Lord, will have a bearing in that matter. Therefore, Lord, she wants an observation here, Lord, that not be not appropriate because what she's trying to say, she took possession on 9/11, Lord. There was no allegation about this. Next day, she not files a complaint and possession is taken along with the police.
It was stated that such application filed within 1 week,
Please note, I'll file an application with it.
within 1 week. List the,
My lordship, even if the water connection is given, the pipe is not connected and he's damaged it, which has been there in page 197. I have produced the photographs, how they've damaged. They've taken a hammer and hammered the pipe from behind. So unless the pipeline is connected, the water is not going to come to the house.
14th February, 14th.
Please,
My lordship, if it
Lord,
can
can I
be,
seek one indulgence, Lord?
It-
Lords have said, not admitting that she is the owner. But that itself is a subject matter of Lord appealing.
We are not saying anything.
Very well, very.
my lordship, if it can be taken up on the 5th of February, my lordship, because I'm coming from Bombay, I have a matter before the single bench on the 4th. I can appear before the bench on the 5th. Ma'am.
Fifth.
Much obliged, my
Great.
lordship. My lordship, my memo can be taken on record. I've already served copies to all of them.
File in the.
Registry, file it.
File it at the registry. Much obliged, my lordship.
Please.
45 to Varadarajan MS.
appear for the accused.
So sorry. So-
The violation of the undertaking given by him is what I am complaining of. Let's kindly come to page 31. The affidavit filed by him in the MFA. Paragraph 3. I submit that in terms of the joint development agreement, the builder developer has agreed to complete the construction of the entire building, including the 4th and the 5th floor in the suit schedule items 1 and 2 property in all respect as per the specifications mentioned in the joint development agreement, and assure to hand over owner's share of the built-up area, including the 4th and the 5th floors, which are directed to be reserved for the appellant and allotted to them in case they ultimately succeed in the original suit by the end of December 2023, with a grace period of 3 months. I submit that I will ensure and follow up with the developer regularly to pursue him to complete the project at the earliest, including the completion of the 4th and the 5th floor in the building in all respect as per the specifications mentioned in the joint development agreement. The builder has also agreed to obtain the occupancy certificate to the entire building before handing it possession of our share as mentioned above. I submit that I am swearing to. Now, this is the undertaking he gives. 4th and 5th floors are reserved for me, for my benefit. That is, the building has 12 floors, except these 2 floors, which has a bare structure. It is not completed in any respect at all, while the entire remaining portion of the building is so completed. This is what I am complaining. This is what I have alleged in paragraph 20.
My lords, may I submit this? My lords, the complainants are the wife and daughters of me. They have filed a suit against me, my father and my family members. Parallelly, my lords, all family court proceedings are also going on. My lords, what had happened? They filed a suit seeking partition of the properties belonging to my father. After his death, I get my share. My brother get my share. So they filed a suit. They obtained ex parte order of temporary injunction. My lords, in the trial court, I filed a written statement as well as objections to the IA. Considering that memo, my lord, I filed one memo before the trial court, which is at page.
Now open for the court to go into all those questions.
No, my lord.
He gives an undertaking that he will complete
No.
4th and 5th.
My
in
lords,
all
this is a
respect.
case where
He has not done that is my grievance in this contempt.
may I submit this, my lords. This is a
He
case.
does not answer that part of my allegation in his objections.
This is a case where he is misinterpreting the order of this honorable court and he is taking benefit of the same. I have given the undertaking that I shall keep a part of the property intact as per the learned single judge's order. After that order, he has filed application before learned single judge directing me to complete the building. So I have filed a counter affidavit as well as affidavit stating that in the 4th and 5th floor of the property, which is a commercial building, my lords, a tech park, I have given an undertaking that whatever the share which I will get, that is 24,000 plus square feet of the property, I will not alienate that property. That was the undertaking which I gave it through the affidavit, my lords. That affidavit is in the page 60. I have produced that affidavit with my statement of objections at page 60, annexure R11.
We'll consider some other day, 31st.
Mention item 53. This is a public interest litigation. The respondent number 2 BBMP has just served a copy of the reply just 2 days back. I'll require 2 weeks to file the rejoinder.
When do you want?
10th of February, it's possible to have it, madam. I come from Delhi. If it can be fixed at 2:30, that will be helpful.
Choose the date.
Yes,
Your date.
10th February,
10th February. 10th February.
2:30.
We'll take up.
47, my lord. There is no interim order, my lord. We have taken very near date. It's number 47.
Dates will be given.
Short date.
Lordship,
That is connected with serial number 62, writ appeal, my lord. The writ appeal matter was stayed. See, they have filed a complaint.
Request for any short. Lordships kindly. PL number 52, list number 1. PL matter relating to Budana lands. Request lordship to list this matter tomorrow.
Tomorrow, not after 4 weeks. Don't be
Lordship, serial number 4.